One order 41 and an application.
And order 41 for hearing. My lord. The only, may I please to indicate, my lord, there is a miss case analogous to this. The LCR has been sent down. However, the record pertaining to the miss case is also
Will
been.
take up, we'll consider.
My lord.
Yes. Yes, you want to something, we'll take from that city.
It's a hearing, my lord.
Application is.
Your lordship.
You?
My lord, this is a matrimonial appeal for hearing.
Hearing we're not taking now.
My lord, the boy will again marry. My lord, the appeal filed at
Not
23.
right now.
My lord.
Your lordship,
No, you-
application.
Yes.
Your lordship, application. Your lordship.
Application order 41, please handle.
My lord, this is from my lord's original side. This is an assigned matter.
When you sit in original side,
Well, can you permit to mention one aspect for inclusion?
hearing no.
No. Only inclusion. Because
Inclusion for some purpose has to include. Only inclusion means no hearing matters now. Sorry, no. Yes.
And my lord, another matter.
Has to be hearing we're not taking now. Page filing, first appeals are not required to be admitted. Where is it? For what purpose? Under which heading? You have filed an application. Mention application, then you are saying first appeal.
My lord,
My
another.
lord, though it's a hearing, your lord, court of.
No.
See, extension.
My lord, may I be permitted to mention a matter before your lordship? My lord, this is a circuit bench matter, my lord. And my lord,
I sitting with whom?
my lord, there's an urgency in this matter, my lord.
Sitting with whom? Which bench? This bench?
No, my lord.
I never
it's a
sat with just got a challenge.
no, lordships, my lord.
I sitting with somebody else must be. Who else? Please take proper information, sir. Yes.
Another matter, matrimonial direction to file my paper book.
Right to be mentioned and then.
My lord, may I mention for hearing, my lord, order in obedience order dated 19 August.
Hearing we are not taking up. Yes.
My lord, I am mentioning for application for
Application, yes.
My lord, I have permit to mention for inclusion for hearing.
No, hearing.
Lord, may I have a lordship's leave, my lord? There is a circuit bench matter, my lord. But this is an FMAT, my lord.
Which bench? Circuit bench? I with whom?
My lord, the bench is not functioning, my lord. That is why, my lord, for urgent filing, my lord.
Acha. You are seeking leave to file?
Yes, my lord. File and
Till
move
the
the
bench,
matter.
next bench commence from when?
My lord, 17th, my lord. This 17th.
Next week.
Yes, my lord. My lord,
File there. File.
as a lordship, please.
Yes. Call on.
Lordship, may I be permitted to mention a matter for inclusion?
No further mentioning today. Yes.
Lordship, application matter.
No further mentioning. Yes. One who is appearing.
Item number 1 for the appellant.
Appellant, you are for the appellant? Yes.
There are the three applications. Can number 1 is the stay application. Can number 2 is the stay application was dismissed for default, my lord. At can number 2 for that purpose, my lord, for restoration. And can number 3, my lord, there is the report from the department that the restoration application file has been filed, my lord, out of time. There is a section 5 application, my lord.
Restoration application is there.
Yes, but that is the can number 2.
Then 2 ta kotha. 1. Can 2 kotha. আচ্ছা can 2 ওখানে দুটো কপি নেই দুটো কপি আছে can 2 have not filed 2 copies?
Yes, of course, 2 copies I have filed.
সেকেন্ড জেন্স কপিটা কোথায় ফাইল রেডি নয় আপনাদের সিম্পল জিনিসগুলো করে দিতে হবে ওটা দিচ্ছেন কেন পুরোটা দিন section 5 is delay in filing the
restoration application.
So you have to serve on the other side. No,
But
restoration.
the order 40 or stage, my lord.
Section 5, some right is.
No, my lord, so far the number 1 is concerned, my lord, that the order dated, my lord, 23rd of 16th of August 2023. But the appeal as well as the can application was dismissed.
What is the reason given? Delay?
Delay, my lord,
You have not given any reason.
Miscalculated. Delay of 30 days.
Miscalculated.
No, my lord, the delay of 23 days.
Means since the appeal is still at the order 41, still at the stage of hearing under order 41 rule 11 of the Code of Civil Procedure, and the same was dismissed for default on August 16, 2023, when none had appeared for either of the parties, comma, prior service of copy of the applications is dismissed with full stop, sufficient reasons having been furnished for the delay in filing the restoration application, as well as for the absence of the appellant on the relevant date, comma, we hereby allow can 3 of 2025, comma, thereby condoning the delay in filing the restoration application. Full stop, consequentially, comma, can 2 of 2023, comma, the restoration application, comma, is also allowed, thereby recalling the order dated August 16, 2023, passed in SAT 146 of 2022, and restoring the said appeal, that is SAT 146 of 2022 and can 1 of 2022 to their original file and number. Full stop. Let the appeal be listed for hearing under Order 41 Rule 11 of the Code of Civil Procedure tomorrow.
Not tomorrow, my lord, don't.
No tomorrow. Then no restoration, sorry. No restoration.
But
No restoration. Then we are recalling the restoration order, we will take it
no,
up
my
whenever you
lord,
are
day
ready.
after tomorrow, my lord. No,
No. তাহলে অর্ডারটা রিকল ছেড়ে দাও।
no, all right. ঠিক আছে।
We are fed up with this game actually. This getting it dismissed for default restoration and then you don't come. No, sorry. If you have to restore, you have to be prepared in the matter. Yes. Who is appearing to?
My lord, I'm praying for a short passover.
Refused. Move the matter. Refuse. Move the matter.
Okay, my lord.
Don't say okay to a court. Don't say okay to a court. Who is your senior?
Short of Gothagurata, he's on his way, my lord.
So what? You have to be prepared with the brief. That's the rule of this court.
My lord, actually.
Then
he's
you are
at-
dismissing for default.
No, my.
Sorry, you have to have the brief with you. This is not done. You are before the highest court of a state. You have to be prepared at least with the brief.
I'm prepared, but
No,
the
no.
brief is not.
Learn an adjournment is sought on behalf of the appellant. Full stop. When we insist that the matter is required to be moved, comma, learned counsel seeking adjournment refuses to move the matter. Full stop. Accordingly, let the matter stand dismissed for non-prosecution. Next.
My lord.
Give your name.
For a not to them.
Sorry, refuse. No time. You mention the matter when it comes to the list. Your yes, Mr. Karim, what is it?
Lordship, I beg. My lord, so far the defect parts is concerned, we have been clear in the section. My lord, now the matter was come up before Lordship hearing.
What is the matter, Mr. Karim? There is no caveat in the matter.
No,
Ask,
no
what is
caveat
it?
in the matter. My lord, the can one is the stay in respect of the order and the memo has been filed.
What is the appeal about?
Against the order, if a Lordship take trouble to the
Judgment of affirmance or reversal, Mr. Karim?
exactly Lordship.
Affirmance. Yes, what is that?
If a Lordship take trouble,
No. What sort of a memo is this? You have not annexed the certificate copies.
my lord, the certified copy which has been annexed, there is some defect on the part of the court below which has been supplied.
No.
to us.
Where are the certificate? We are asking for the certificate copies.
In the memo, my lord, it has been annexed.
No, it's not there. That's
My
what
lord,
we are- Very well. It arises from a preliminary decree of partition.
no, final degree.
Preliminary decree. It was decreed, preliminary form.
Lordship.
So what is your ground?
My lord,
You are the
my-
defendant, obviously.
Lordship. Now, here,
Yes.
my lord, so for the agreement for sale, which has been executed by the actually owner in respect of the said property, that document was not been considered by the court below. This is the sole ground before Lordships.
But agreement for sale doesn't give you a present right.
Lord, I know, my lord, because there is separate my lord, specific performance act to be filed
Yes.
before the court, and there
And
are
Section 54 is clear, agreement does not create any right.
Lord, now. If
So
a lo-
then you don't have any ground, Mr. Karim.
no, my lord, if a lordship, my lord, one ground. You don't
What is the
have-
ground?
my lord, if a lordship takes trouble to the Lord, my
মেনশন করার সময় এখান থেকে ওই পর্যন্ত লাইন মামলাটা শুনবো
first part, second part, my lord, what I try to assess your lordship, my lord.
Yes. What is your ground, Mr. Karim? Be short.
My lord,
Second appeal, not lengthy hearing. Appeal judgment itself is 5 pages long and you are taking 5
No,
minutes.
I know, sir.
Then you don't have any ground.
But so
Just
far
go through the formalities so that we can dismiss it. If agreement is your ground, first ground, then you don't have.
so for the dismissal, your lordship can pass any order, subject to kind sanction, unless your lordship.
What is your ground? Substantial
So
question of
if your
law.
lordship state were kindly come to the the petitioner herein, they have been sought for partition before the court below on the strength.
You have sought for partition. You are the defendants, I thought.
No, initially I have the I am the plaintiff. I have sought for the partitions.
All right.
That has been denied by the court below.
Or suit is dismissed.
Dismiss. Thereafter, against that, I preferred an appeal,
that.
and that has also been negated by the appellate authority. Against that, we have come up before lordship.
Yes. So what is your ground? Still, we don't know your ground.
No, my lord.
What is the substantial question of law involved?
My lord, I try to your lordship kindly come to the inner page. Very page 35.
It was decreed preliminary in preliminary form,
Lordship,
not dismissed.
not dismissed.
You are not ready, Mr.
My lord, be frankly, just I have received the brief today. For that reason,
You are going-
I'm not asking for any accommodation.
Why did you mention the matter?
My lord, as the defect was not been clear earlier, twice we have tried level best.
Learned counsel for the appellant is not prepared in the matter.
Oh, my
Let the
lord,
matter go out of the list
my lord, one
with
modest-
liberty to mention when learned counsel finds
my lord,
time
one
to
modest
get prepared.
My lord, one
Next.
modest prayer, my lord.
Sorry, no.
My lord, leave
No,
may
no.
be leave may be granted.
This is not we don't have the time. Sorry. Yes.
Time for the appellate.
Yes.
My lord, and
I could have practiced. Mr. Mukherjee, yes.
Yes,
You have started a very bad day. Please make our mood better.
I will try. But here, the
We don't get any sadistic pleasure in dismissing matters, but people have to be ready. 1, 2 item. First one adjournment short. Second one counsel not ready. He says it's dismissed. The suit is dismissed. We find its preliminary degree has been granted. Second appeal before the High Court of the state. I don't know. Anyway, let us move on with whatever we have.
the suit for eviction.
You are the
I'm the tenant, my lord.
tenant.
Both
So-
court, my lord, I lost.
Well, yes.
The ground,
Respondent. Mr.
Well, I will capital respond.
Take a seat. Yes.
the ground by the trial court is with regard to the default for 2 month payment in respect of 7(1)(c). With regard to 7(1)(7)(2), no quarrel, but 7(1)(c), 2 months, Lord, I have been found to be defaulter since within the 15 day of the each succeeding month that was not done. That is one ground. Another ground is of the reasonable requirement. Lord, with regard to Lord, the 2 Lord, default under 7(1)(c), one is Lord, in 2021 when COVID was there and that benefit was granted by the learned trial. So it remains one default with respect to the month of October. There, the puja holiday, I filed a section.
97 Act. Miscellaneous Act 97. Yes, please continue.
Yes,
We'll catch up.
There, the month of October, it ought to have been filed by the November 15. It is of the year 2016. 2016, puja holiday started on 30th September 2016 and the court reopened on 2nd of November 2016. And so I ought to have deposited within 15. The currency, your lordship knows, that point of time 500 and 1,000 rupees, that currency was banned, that was done on 8th of November 2016, and that goes on up to 30th of November 2016. So ultimately, I deposited on 23rd of December 2016. So this is the default which I paid under section 151 since the currency was banned. So that benefit, it is also beyond my control. So far as regards this 7(1)(c) is concerned.
Does the court have the power in convince us of that?
In my
not your fault maybe, but now it's rather draconian in a sense.
But your
Does the
lordship
court have? If the court does not have power, we cannot invent a power.
Milord,
151
if I-
can be exercised if there is no specific bar.
Yes, Milord, if I take the analogy of COVID also, Milord, that is also beyond our control and the court has intervened. It is also one of the classic case where
But
Milord, it's-
demonetization, no such orders were passed by the Supreme Court. COVID, we take advantage of the orders of the Supreme Court. And if there is a power of the court, definitely we are liberal on demonetization also. We know what happened, all of us. So, but if the court doesn't have the power, Mr. Mukherjee, we are helpless. We have full sympathy for your client.
I say, Milord,
151
this
can we invoke?
this particular aspect, Milord, with regard to Milord, the consideration with regard to the situation, that has not been gone into Milord in any of the judgment. Yes, generalized Milord, yes, there is no power. But with regard to this kind of situation like COVID, where the court
It's not
intervened,
dependent on the situation. It's on the court's power. It's more serious. If the court does not have the power, court's power has been curtailed now. That provided that having regard to the circumstances of the case, an extension of time may be granted only once. Period of extension shall not exceed 2 months. Then that's a blanket provision, actually.
and Milord, this 7(1)(c), Milord, our special bench, your lordship knows, Milord, our special bench has given that the 7(1)(c) benefit, Milord, Milord, the proviso appended to 7(2), that benefit will also be, Milord, granted in respect of 7(1)(c) also once.
By the same logic, the regard also applies to 7(1)(c).
Yes, Milord, that's why if Milord, the proviso appended to 7(2) benefit is granted once, I am within time, even in 2016, because I deposited within Milord 2 months. So Milord, 2 months is the Milord.
And you made the application.
Yes. That 151 was taken up, Milord, at the time of hearing, and court said
taken up.
Yes,
you filed the application and made the deposit within 2 months.
Within 2 months from the date of Milord, yes.
Last date.
Last date. That is on 23rd of December 2016. I am coming well within period of 2 months.
Then the question is whether the proviso is applicable.
Yes. With regard to 7(1)(c).
The reasonable requirement?
Yes, Milord, I am coming to the reasonable requirement. Kindly once now takes up, Milord, the trial court judgment. It was subsequently stitched, Milord, I have been told. The ground pleaded, Milord, in the amended plaint, one paragraph was inserted. He said that he has a separate residential accommodation. This particular property is being purchased in 2012 and this suit is being filed in 2015. He said, I have a godown in the suit premises. I want to shift the actual business is running from his residential home, which is separate one. He want to shift it. That is the ground of reasonable requirement. His business. Godown is
shift
in
the business here to the suit premises.
To the suit premises.
Yours is a ground floor thing.
Mine is a ground floor. Now, Milord, kindly takes up, Milord, internal page 11 of my Lord's trial court judgment.
Yes, we are there.
Last but one paragraph is the only paragraph.
The only question.
Yes. Now, Milord, in the evidence, it has come from the cross-examination of the plaintiff's witness number 1 that there are other tenancies in respect of the suit property. Against 4 of the tenant, an eviction suit is being filed. Thereafter, the suit has been withdrawn. Fresh tenancy agreement has been executed with regard to the 4 of the separate tenants, and still their tenancy is going on. This is, Milord, one of the aspects. Second, local inspection held. Local inspection, one of the point was there on the plaintiff side, how many rooms are within the accommodation of the plaintiffs. As many as, Milord, 4 bedrooms, kitchen.
Which floor?
Ground as well as first floor.
Ground floor, what is the, have you got a commissioner's report, a copy of the commission?
Yes, I'll immediately hand over.
You want to see the ground floor rooms. You will please find that out and then hand.
Yes. Okay. Item number 2, application on Order 39 Rule 7 of Civil Procedure situated at HMC, holding number 21, Kaliprasad Banerjee Lane within the police station, Batra district, Howrah. In the ground floor, the plaintiff have 2 bedroom, 1 kitchen, 1 bathroom, and in part portion of the ground floor of the plaintiff have 1 room and 1 PV with the shaded roof. In the first floor, the plaintiff have 2 bedroom, 1 kitchen, 1 bedroom, 1 bathroom. In the roof, the plaintiff has 1 Thakurghar. kindly takes up, this is a part of point number 3 in the commissioner's
No,
report.
trial court, this was not an expertise degree.
No, but the trial court said
So this
Seven-
is the only
this is the only observation with
page
regard
11, page 11
page 11, my lord.
regarding
No, the court said, my lord, that part also I will read. The
Hmm.
court said since 7(1)(c) default, so my defense strikeout, so I will be held defaulter since I don't have any defense case, so I will be held defaulter since from the day as pleaded in the plain. But 7(1), 7(2) benefit already granted. It's a only default in respect of 7(1)(c). There also the court lies wrong. Continuation of page 10 will give that, my lord. It is only with regard to the 1 month of 7(1)(c), because with regard to the COVID, the court has
you
already.
say that the relief under 7(4),
Yes.
rather 7(1), 7(2).
It has to be 3 consecutive months.
That is independent of the striking out of the defense.
Yes. So there also, my lord,
If that point you succeed in that point, that 7C is not beyond time or
yes,
can be condoned, then
Then-
the entire thing,
then
even
entire-
without a written statement, it actually
yes.
could have.
And my lord, with regard to the reasonable requirement, the cross-examination,
Where are the findings regarding reasonable requirement?
only, my lord, the finding I have
This
shown-
much.
This only one paragraph.
This, please read page 11.
Yes, my lord, page 11.
The third last paragraph, the plaintiff also paid for
The
eviction.
plaintiff also paid a decree for eviction on the ground of reasonable requirement. The plaintiff's husband deposed on the plaintiff's behalf and proved her claim. My lord, I will show that portion of the cross-examination. The plaintiff also proved the reasonable requirement through the local inspection report. Exactly the contrary. Peruse the local inspection report, which is marked as Exhibit 8. The assertion of the plaintiffs remain unchallenged and the ground of reasonable requirement is sufficiently proved. The court is went on, my lord, with regard to that
How
striking.
will
of-
the appeal court deal with this?
Yes, my lord. Appeal court only, my lord, reiterated whatever the finding are. My lord, kindly takes up the appellate court judgment. Because in the appellate court, the reasonable requirement goes in there against. That's why they filed a cross appeal in the appellate court
Why
with
proceeding?
regard to the reasonable requirement.
Trial court granted degree also on reasonable requirement.
But my lord, a cross appeal has been filed since in so many language, I believe it has not been dealt with. That's why on precaution, perhaps the plaintiff filed a cross appeal before the appellate court. That cross appeal also got dismissed on merit.
At a order now. This appeal shall be heard on the following substantial questions of law. 1. Whether the learned courts below substantially erred in law in granting an eviction decree on the ground of default in payment of rent on the sole ground of a single purported default under section 7 within bracket 1 within bracket small c of the West Bengal Premises Tenancy Act 1997, without considering the fact that an application for condonation of the delay along with the deposit had been made within the statutory period of 2 months as stipulated in the proviso to subsection 2 of section 7, and as such the said late deposit did not tantamount to a default. Next, Roman 2, whether, in view of the defendant stroke appellant having been granted relief under section 7 within bracket 1 and 2 of the 1997 Act, the courts below substantially erred in law in holding the defendant stroke appellant to be a defaulter as per the plaint allegations, without considering the legal position that the remedy provided under subsections 1 and 2 of section 7 are independent of the defense of the defendant being struck out. Roman 3, whether the courts below acted contrary to law in granting an eviction decree despite the appeal court having dismissed the cross objection filed by the plaintiff against the portion of the trial court's decree whereby there was no specific enumeration on the ground of reasonable requirement. Roman 4, whether, in view of sufficient alternative accommodation being available to the plaintiff landlord on the ground floor of the suit premises, as apparently evident from the advocate commissioner's report, the courts below substantially erred in law and in a perverse manner in granting eviction decree despite also on the ground of reasonable requirement, despite the reasonable requirement of the plaintiff having not been proved. Stay application is there, execution has started.
Yes. Police help also granted, not can one.
Mr. Singh will grant you liberty to file opposition for the occupation charges.
My lord, I wanted to point out one
Yes,
paragraph of the appeal court judgment, my lord.
yes.
Page 11.
11. Yes.
My lord, see, whichever my learned friend has argued, everything has been considered by the appellate court.
In one sentence.
My lord,
As per which case?
third paragraph.
Seen that. We have seen that thrice to find out any details. Nothing is discussed. Plaintiff has proved his case. This cannot be a judgment. I will add another ground. Thank you. Forgot that. Arekta ground add kore daw. Whether the judgment of both the courts below ought to be set aside on the ground that both the courts, that both the judgments are ex facie cryptic insofar as the consideration of the evidence, particularly on the ground of reasonable requirement is concerned. That is another one. Because that is the ground on which that played in our mind. You are right. It has been discussed, but in one line. He's proved his case. Achha, execution has been levied.
Yes, but execution number 13 of 2023.
Can 1 of 2025 is taken up for hearing, full stop. Since we have admitted the second appeal by framing substantial questions of law, a prima facie case has been made out for grant of stay. Full stop. Accordingly, there shall be stay of all further proceedings in title execution case number 13 of 2023, arising out of title suit number 595 of 2015, pending before the learned civil judge, junior division at Howrah, till disposal of the application. Full stop. Next para. The respondent shall file her affidavit in opposition within how much time, Mr. Singh? You'll have to disclose some details about the occupation. Within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall be listed before the appropriate learned single judge having determination in the monthly list of December 2025, subject to the convenience of the said court. Next para, it is, however, made clear that the question of imposition of occupation charges as a condition for grant of stay is kept open for being considered at the time of final disposal of the application.
And my lord, depositing of the occupation charges, my lord, already continuing, nothing has been.
No, that we have kept open, because when it will be imposed, it will be from the date of the decree. That is the law. Yes. So that's why you have kept it fully open.
My lord.
7th court. আচ্ছা ওখানে যেখানে বললাম 7th court. Civil Judge Junior Division 7th court at.
But may I take back the commissioner's report?
Did you give it? We did not look into it.
Yes.
Take it back.
Great.
You read out, so we thought he had not handed over.
No.
Yes.
Item number 5.
No, I'm led by Mr. Shaunak Bhattacharya is coming. I will start.
Yes. We are seeing you after a long time. How are you?
Fine.
Yes. What is the matter?
Matter is that it's a suit for eviction against a tenant. I'm the tenant, unfortunate tenant of the appellant.
Unfortunate or not, we'll know soon. You lost in both the courts?
Both the courts.
On what ground?
2 grounds were taken in the pleadings. One was the default, another was the reasonable requirement.
Yes.
The suit property comprises of a shop room The landlord wants the shop room for his garage. This is the crux of the cases of the plaintiff. So the suit was duly contested, and the suit was decreed on the both two grounds, reasonable requirement and the default. Thereafter, appeal preferred. The appeal court, first appellate court, affirmed the judgment. So now the trial court, my lord, framed as many as 8 issues. First issue is that is the suit maintainable? That is the not. Is there any cause of action? That is redundant. Whether the defendant is monthly tenant, that is.
Let us forget those. What is your substantial question of law? Second appeal only, that is a scope.
Now the
formulate your substantial questions of law.
Now the appellate court has rejected the appeal on the ground that there was no 7172 application filed by the developer. That was the ground. And the argument advanced by the tenant appellant before the appellate court and trial court, that since defense was not struck out, in spite of having not filed 7172, defense was not struck out. The tenant was given opportunity to give evidence. If the defense was struck out, then the defendant tenant would not have got opportunity to adduce evidence. That is a very peculiar observation. So defense was not struck out in spite of not having been filed by 7172 application.
No, not defense will be struck out. Defense is behind you. So he will be struck out. Yes. Why shouldn't we strike you out? What is this point? Defense strike out?
No, defense, my lord.
Being developed, but then you entered.
Yes, my lord. Kindly see, my lord, there is a finding that, my lord, there was a...
Calcutta did not strike out the defense. And you had not actually filed a 7172.
72.
71 you had made the deposits.
My lord, there was also default.
So 72, why are you so happy about that? 72.
But
so non-compliance of 71 and
definitely,
72.
definitely. My lord, another thing, my lord.
And what did the appeal court say?
Reiteration, my lord. Trial court, nothing more.
So trial court said what? Permitted you to lead evidence. That should not be looked.
Now, my lord's judgment, my lord, has come, my lord.
What judgment has come?
That Thika property, my lord, which I argued, my lord.
What did I say there?
Says that, my lord, even if, my lord, defense is struck out, my lord, on the cross-examination.
No, that is settled. That is settled. Not my judgment.
And, my lord,
much wiser than us.
And, my lord, regarding reasonable requirement, my lord.
No, they had to prove their case.
Definitely.
But then, even if defense is struck out,
this is a room.
7172 is not filed, then you are guilty of default. You should go on the ground of default only.
The court has held that I am not entitled to get benefit of proviso to section 7.
Yes. On that ground only. And reasonable requirement?
Reasonable requirement, my lord. This is, my lord, room, my lord, in the middle of the house.
We'll not go into that.
My lord,
We'll say that
my lord, how, my lord, this is, my lord, not for, my lord, staying. My
garage,
lord, for
garage.
parking
Garage.
Garage, yes. That is the only, my lord,
middle of the house.
Middle of the house, and although in the ground
is lucky because you go on.
And the grocery shop, my lord, is running from there, and it has come up, my lord, as the, my lord, report of the, my lord, commissioner. It says there is a, my lord, wooden, my lord, gate, and there on the portion, my lord, just outside, my lord, the that room. My lord, I do not know whether that is conducive, my lord, for parking cars.
So, what is the first ground you tried to formulate regarding default? I mean, 7172, the default remains. No deposit under 71. So, what is the ground you are trying to formulate? You have to say something on your mouth.
My lord, my lord, in one ground, my lord, plaintiff is entitled to get, my lord, that degree. My lord.
Learned counsel, the present appeal, second appeal.
There was no formal order, my lord, for that is, my
striking
lord,
out defense.
Striking out. That was your lordship judgment, my lord, in the other
that's
matter.
true. Even without striking out defense, you are gone.
My lord,
that's the difficulty.
No, my lord says, my lord, that is not automatic. Court has to, my lord, give, my lord, a finding.
We are not saying your defense was struck out. You are guilty of default under the.
I am not entitled to get section of 7.4.
Yes, even without striking out defense, your defense. The present second appeal has been preferred by the defendant tenant in a suit for eviction on the grounds of default and reasonable requirement under the West Bengal Premises Tenancy Act 1997. Puts up next para. Learned counsel for the appellant argues that despite there being no deposit under section 7 within bracket 1 of the said act, and no application under section 7 within 2 of the 1997 Act having been filed, The defense of the defendant stroke appellant was never struck out. Full stop. As such, comma, it is argued that the courts below erred in law in granting a decree of eviction also on the ground of default without granting the appellant the protection under section 7 within bracket 4 of the said act. Full stop. Next para. Learned counsel also makes his submissions on the ground of reasonable requirement. Full stop. However, comma, in view of the appeal not being sustainable at the first blush on the ground of default in payment of rent, and it being a well-settled proposition of law that if the plaintiff landlord succeeds even on one ground enumerated under section 6 of the 1997 Act, comma, the plaintiff is entitled to get an eviction, and the adumbration on the other grounds is rendered irrelevant. For some next para, on default, comma, we are unable to accede to the submissions of learned counsel for the appellant, comma, since in view of non-compliance of even section 7 within bracket 1 of the 1997 Act by making deposits as enumerated therein, comma, the present defendant stroke appellant was lost the cloak of protection as provided under section 7 within bracket 4 of the 1997 Act, comma, irrespective of the defense being struck out or not. Full stop. Hence, comma, the learned courts below were justified on the ground of justified in granting eviction on the ground of default in payment of rent. Full stop. As such, comma, we need not look into the other ground of eviction as the decree is required to be sustained, as the decrees of both the courts below is required to be sustained on the above ground alone, comma, if not on the other grounds. Full stop. Accordingly, SAT 205 of 2025 is dismissed under order 41 rule 11 of the Code of Civil Procedure. Consequentially, can 1 of 2025 stands dismissed as well. No address to cost.
Lordship, I beg to appear on behalf of the caveator, respondent number
Aviator.
1, 2, and
The size there.
My senior is there.
I am also being led by Mr.
Oh, Mr. Bakshi is there. You're led by Mr. Basu. We can't see Mr. Basu.
Oh. The Supreme Court pending আছে জজ সাহেবের আর্লিয়ার
ওই রে ক্যাবিনেট তো চুপে বস এসব ঘরে সব করবি না একদম
Yes, Mr. Bakshi, what is that?
আগে আর সুপ্রিম কোর্টে গেছি
না সেটা স্যার ইনস্ট্রাকশন আছে
They're trying to intimidate you. So, Bakshi, what is that?
plaintiff before your lordship against an order rejecting application for injunction under order 39 rule 1 and 2. My lord, the report is wrong.
What is the report? Not even looked into the report.
দাদা রিপোর্ট কিছু আছে
Within a month we have filed the application.
কিছু রিপোর্ট আছে
Defective out of time, আছে.
আমাকে বলেছে রিপোর্ট আছে
Yes, yes, there is a report defective out of time.
দেখেছিস রিপোর্টটা দেখেছিস
18 days delayed state. Let us just look into
the
that.
report is wrong.
We'll just check up. 29.3.
What the ones?
May 63. May the 63.
No, that's like
27 days. That's
within a month appeal has been filed. 13
18 order 16/7 file
when entire order sheet has been given. That is why the
you are challenging order dated?
order
Order
18/6
13
order number 13 June
13
18th June.
18 June
Because you have given the entire order sheet, that's why. Yes. Mr. Bakshi, why is this done? I mean, we can just take a separate certified copy of the impugned order. Then
that is better, or a
yes, you have taught us.
or a note.
no that thought will not do now
Not true.
you have to fix it in the bottom of the memorandum at the top you have to give it another copy I don't know who has applied this mind for this.
Separate certified copies to be applied for the field order and the other order sheet.
Bottom, in the memorandum,
in
they have
such-
text. Then at the top, you have to give in one another copy. Why?
Well, that is procedural law. I'm not.
Mr. Bakshi, let us come to the merit.
I don't know. Twice I have been consulted. I don't know whether I have advised them to give a note.
Let us forget that. It's not time, but you are right. Yes.
My lord, injunction refused. Society and its property is the problem.
What is the suit for?
Suit for declaration of status and injunction.
You have captained it to be one under section 92. So what
Your
was
lordship heard this matter before in interim stage, and your lordship refused interim injunction.
That is immaterial, but now at the final stage it's different.
My lord, my threefold submission. The order has no ordering portion, has no foundation in the
reasoning
judgment. On the threefold ground, application has been rejected. Delay in filing suit. Delay in filing suit is no ground.
No, it's an equitable relief, Mr. Bakshi.
Yes.
It's an equitable relief.
Yes.
Equitable relief. So delay may defeat
Power is a statutory relief. And my lord,
Injunction
delay
is
has been
Injunction is not a matter of right.
Except in order 39(1)(2), there is no question of delay. It was filed along with the suit. And my lord, in case of ex parte injunction with the notice, by amendment, question of delay has been introduced. Only, my lord, if ex parte injunction is without notice issue, court has to give a reason that the party cannot wait. But not so for order 39, rule 1 and 2. And it is filed along with the suit. 3 application was filed: suit, injunction application, and the order 92 application. Therefore, there is no delay in filing because it was filed along with the suit.
What is your allegation in the suit? Main allegation?
Allegation, my lord, are twofold. I am a donor, founder, member, as well as secretary. I have been dispossessed from property as well as post illegally. I have no proper notice was given, and
this is a society under the society's registration.
Without giving proper notice, within 24 hours notice, the secretary has been elected. New secretary has been elected.
What is the injunction
that
you are
is
seeking?
Against the provision of.
What is the injunction you are seeking? What injunction are you seeking, Mr. Bakshi?
1 or 2 injunctions I am seeking.
Yes.
Restraining, not to restrain me from entering into the premises. First. And second is, my lord, I should be permitted to work as a president. Secretary.
But that would be allowing the suit itself. Decreeing the suit.
Second will be allowing the suit.
Second one.
The main mistake has been made in such a case. Learned judge, my district judge, was pleased to hold. Yeah, I am in a dark. It is his duty to protect the property.
No, he's in the dark because he says because you have.
If he's a dark about the fact,
no, you have to plead something since 6 February 2024.
Kindly see order number 30.
Yes, page 12. Since 6 February 2024, he says he's in dark about the activities of the Shomiti and administration of property. 6/2/2024, since then, you have not pleaded anything. In the order, Mr. Bakshi, it's recorded that this court is totally in dark about the activities of the Shomiti and its administration and properties since 6th February 2024.
Yes.
A person who had kept quiet for a long time and allowed another to deal with
Yes,
the property.
that
That
is
principle.
what I'm saying.
Yes. What is your answer to that?
If court is in the dark
Court has to go and find out.
about the affairs of the society, that
Court
is
has
the
no
case
such.
of receiver. Because injury to the property, that is the question. It is nobody's private property.
Even
Property is to be my
the
lord.
plaintiff's prerogative to at least bring
Yes.
before the court what are the materials. Then the court can look into plaintiff's prerogative to bring before the court the materials. Court does not have any business to
My
go and
first
inquire of his own.
submission, a donor or cannot be prevented from entering into the premises. And he is a admitted donor. Or so far the second in the reply, my lord, they are alleging we have defaulted in the matter of money. Last portion of the order. And we are saying you have defaulted.
What is the injunction prayer?
And therefore, my lord, it is a case of receiver. Because
Receiver at the ask for the asking.
Injury is to the society. It is not a private property.
Injury, you have to prove there is an injury. There is no allegation of mismanagement.
Yes, injury, because that nobody could clear the.
Your lack of ingress cannot injure the property. There cannot be an injury to the management of the society. You have not alleged any mismanagement or defalcation.
Yes.
Defalcation.
Yes, alleged.
Nothing
Page
of that
52.
sort has been alleged.
Page 52. Have alleged.
And they are also alleging that during our period we have defaulted.
Similar. Then allowing you to enter at this stage, Mr. Bakshi, would be, I mean, when, according to you, when were you ousted?
6th February.
My lord,
7th February. 7th February.
7th February 2024.
Yes.
So, and you filed the suit much later. When did you file the suit?
Within 1 year.
1 year, no, not limitation. But for 1 year, you were sitting tight and suddenly what? Why? On what ground, Mr. Bakshi? Yes.
In a, it is a court of law, not court of equity. Therefore, if my right is infringed,
Mr. Bakshi, we cannot admit
it is if my right is infringed, then my lord, I must be restored to my position.
Sorry, Mr. Bakshi, no interference.
Yeah.
The present appeal has been preferred against an order whereby the plaintiff's application under Order 39 Rules 1 and 2 of the Code of Civil Procedure has been dismissed on contest.
My case is illegal dispossession from the post and
We'll advert to that.
In a suit.
So the suit was filed inter alia for declaration and injunction, also seeking relief under Section 92 of the Code of Civil Procedure. First up, the allegation of the plaintiff is that despite the plaintiff being a donor and a founder member of the concerned society, he was ousted from ingress and egress to the society as long back as from February 7, 2024. First up, next para, learned senior counsel appearing for the appellant also argues that the relief under Order 39 Rules 1 and 2 of the Code are legal reliefs and not merely equitable reliefs, and as such, the learned trial judge acted contrary to law in holding that due to the delay in filing the suit, the plaintiff is not entitled to injunction. So next para, learned senior counsel further argues that the court observed that it is totally in the dark about the activities of the society and its administration since February 6, 2024, and the person who had kept quiet for a long time would not be entitled to get an order of injunction. However, it is argued that such premise is also contrary to law, since in a suit of the nature under Section 92 of the Code of Civil Procedure, it is the duty of the court, as the guardian of the property of a society, to inquire into and obtain materials as to the whereabouts of the functioning of the same. First up, next para, learned senior counsel further argues that the appellant is entitled to reinstatement in the post of secretary from which he was illegally ousted. For the next para, after perusal of the impugned order, comma, we do not find any illegality or irregularity in such order. For sub next para, insofar as the argument of the appellant that the court is one of law and not of equity under Order 39, Rule 1 and 2 of the Code of Civil Procedure, comma, we are unable to agree with such contention. Full stop. Although Order 39, Rules 1 and 2 of the Code define the contours of the procedure in grant of injunction and the parameters thereof broadly, comma, at the end of the day, comma, injunction is definitely an equitable relief and not a matter of right for the asking. Full stop. Next para, the court is definitely entitled to look into the delay, comma, since delay defeats equity. Full stop. In the present case, comma, admittedly, the plaintiff was ousted from the property of the society from February 6, 2024, but filed the suit only on March 29, 2025, that is after a clear year from being so ousted. Full stop. Thus, comma, we are unable to find that there would be any irreparable injury or that the balance of convenience and inconvenience is in grant of injunction in the event the temporary injunction sought for by reintroducing the plaintiff into the property of the society is not granted. Full stop. Next para, that apart, comma, we also find that it is the plaintiff apostrophes prerogative, comma, as the dominus litis, comma, to bring before the court all material allegations justifying an order of injunction. Full stop. In the absence of the same in the present case, comma, we are of the opinion that the learned trial judge was justified in passing the impugned order of dismissal of the injunction application. Full stop. That apart, comma, it is well settled that the appellate court does not interfere if a judicial discretion has been used judicially by the trial court. Full stop. In the present case, comma, merely because a separate view might have been possible, comma, it is not for the appellate court to interfere with the impugned order. Full stop. In view of the above, comma, FMAT 288 of 2025 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Can 1 of 2025 is also dismissed accordingly. There will be no orders to cost. It is made clear that none of the above observations are conclusive for the purpose of the suit, and it will be open to the learned trial judge to decide all issues in accordance with law at the trial of the suit without being prejudiced unduly in any manner by any of the above observations. Yes, Mr.
Report, my lord, clarify. বলো না। Report, there is a report that has to be clarified.
Yes. প্রথমে একটু করে দাও। We find from the certified copy that the report of the stamp reporter that the appeal is out of time is erroneous. Full stop. Accordingly, we take up the appeal for hearing under Order 41, Rule 11 of the Code of Civil Procedure.
Page 162, Your Lordship.
Yes, sir.
Kindly see, we are bound by the order. Kindly see.
162.
162 of the application.
Yes.
Page.
নোটিশ দিয়েছে 6টা 6 ফেব্রুয়ারি 3টের সময় 5টার সময় মিটিং হলো ঘন্টা
Yes, we are on the not on the suit merits of the suit. You may have a good merit in the suit, but we don't want you to be introduced again.
2 hours.
That has been recorded by the
Mr. Bakchi, you may have a very good case in the suit. We agree with that. You may have, but we are on the injunction whether you should be reinstated right now. That would create more trouble than it would solve.
No, preventing me from going to office.
But that is not
That
the case,
that
madam.
part.
Win the suit, where a crown and enter.
That is the one question.
Not at this stage.
The donor member should be prevented from visiting the place. That is not equity even. That is not equity.
Next one. Yes, fine.
Appellant loss.
Is also out of time. It's reported.
Yes, lawsuit
It is actually out of time.
255 days delay. Lawsuit, I file the application. Can 1 for paying for condemnation delay.
250. Then you have to serve copy and copy.
Yes, Lord.
Very. The petitioner shall serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondents, indicating that the applications shall be taken up for hearing on November 24, 2025, when an affidavit of service to that effect shall be filed. Top time word delayed.
I think they're there, my lord.
This is also time word.
My lord, it was appeared yesterday, my lord. That matter, my lord. I've heard.
Achha, you had served copy?
Yes. Yesterday, the learned advocate.
He did not have a copy of who was appearing. Uttiyo Mullik.
Uttiyo Mullik. He was standing outside. He is coming.
Come, Mr. Mullik. The court is waiting with an invitation letter for you.
My apologies.
Oh, yes, what is the matter, Mr. Vital?
My lord,
Now you have got a copy of the yes. What is the matter?
my lord, delay of 97 days. Section 5 is there.
What is the reason?
My lord, from para 8 to 12, my lord.
Advocate.
Advocate, my lord.
You have to give a notice to the advocate.
My lord, the
Standing
advocate on record himself, my lord, lost.
Advocate on record himself. Then it's all.
Lost the brief, my lord. It was mistake.
He's still on record.
Yes, he's still.
Then it's all. Yes, what do you say? Renovation work in the advocate's chamber. Happens to everybody. So upon hearing learned, we'll allow that and then take up them. Upon hearing learned counsel for the parties, we find sufficient explanation for the delay in preferring the appeal having been made out. Accordingly, Can 1 of 2025 is allowed, thereby condoning the delay in preferring FMAT 345 of 2025. No order is to cost. The appeal is now taken up for hearing under Order 14 Rule 11 of the Code of Civil Procedure. Yes, please.
My lord, plaintiff appellant, my lord.
Yesterday we probably said that service on the others is not necessary.
Yes, sir.
For the injustice, sufficiently represented. Yes. Yes, service has been effected on 2 to 4. Yes, what is the matter?
My lord, plaintiff appellant.
We may dispose of the appeal also, because if we find that it's short.
Yes, sir. The injunction application, my lord, vacating of injunction application, order 9, order 39, rule 4 application.
You are the defendant in the suit.
Plaintiff appellant.
You got an ad interim injunction.
Ad interim injunction.
Therefore, 39(4) has been allowed by this order.
Allowed by this order, thereby consequentially rejecting the order 39 rule 1.
Oh, the main application has been.
My lord, what has happened, my lord?
Yes.
The application itself was, my lord, rejected on, my lord, 17th of October 2023, without noticing that by the impugned.
What had been rejected?
Order 39 rule 4.
The self-same application. Yes. Then we have to recall this order.
My lord, kindly have a look to page 197. I have entire certified copy I have annexed.
Oh.
And matter was posted ex parte against the defendant number 1, that the respondent number 1. 197.
196, you said?
7. It starts.
Yes, sir, obvious. Oh. It was never restored.
Never restored, never recalled.
Yes, Mr. Mullik.
Ex parte was not, the matter was not, my lord, recalled from ex parte board. And my lord will find all
the injunction application also have been gone into on merits.
No.
In the
No,
present impugned order?
No, my lord. Only order 39 rule 4 has been discussed. And my lord, consequently, my lord, kindly come to the ordering portion.
Oh, acha. No, but the trial court should have taken up the injunction application itself for hearing. Mr. Mullik,
it was heard, my lord.
You just see.
My lord, kindly take
The findings of the court.
201.
No, come to the impugned order internal page. Just look at the impugned order.
My lord,
entire discussion is on that they have suppressed material fact, and therefore it's recalled. The interim order is ad interim order is vacated.
My lord.
But then court does not suppose the ad interim order is vacated, because at this stage of obtaining it there was suppression. That does not entail automatically that the 39(1) to itself will be dismissed. That has to be heard on merits.
My lord, that has been heard. If my
Where
lord,
is
takes
the
page 201. That's the impugned order, my lord.
Impugned order, yes, which portion show us?
My lord, at the top, my lord, parties have taken their respective steps. Date is fixed for orders.
What is the finding on the injunction application? We don't find anything. The narrative of the cases of parties, and then come to the second page on perusal of the agreement. That is the middle paragraph. Perusal of the agreement for sale annexed to it appears it is agreed such and such progress in terms of
The tripartite agreement alleged, my lord, alleged tripartite agreement annexed with the order 39 rule.
What false statement did you make? What did you suppress according to the court?
That the tripartite agreement, as per the clause of the tripartite agreement, that a bank is entitled to give money in entirety to the my lord, to the developer. That is not the clause.
You are the developer.
No, I am the home buyer, my lord.
Landlord.
Home buyer, my lord.
Home buyer.
Even the project is incomplete.
Suit is for what? Specific performance?
Suit is for, my lord, to, my lord, obey the terms of the agreement, my lord.
Obey the terms of the what's the meaning of that?
Particularly a particular clause.
Bound to act in terms of, in garb of this, you are seeking specific performance. Bound to obey terms of the contract means you are seeking specific performance.
My lord, only
you are trying
one
to avoid
thing,
court fees.
No, my lord. The terms, my lord, 8.3 of the clause, my lord, the loan agreement says there are stages to be money to be disbursed to the borrower. My lord, even the project till date is incomplete. The entire money has been, my lord, paid by the bank to the my lord, developer. And not only that, my lord, will find the developer is not coming.
Now, this is a vague relief you have sought. In the suit, your main relief is that the defendant number one is bound to act in terms of agreement for sale.
Yes.
Dated such and such. What is this meaning of this bound to act? Bound to act in terms of the agreement for sale is
No, my
specific
lord,
performance.
kindly come
You
to
cannot
the,
seek a declaration without a specific performance. This is bad under 34 then. Specifically.
kindly come to
page 28.
Yes.
See the
defendant
first
is
relief
bound
without
to
the
act
first relief.
in terms of para, my lord, clause 8.3.
Read out relief A.
Yes, that the defendant number one is bound to act in terms of the agreement for sale dated such and such executed between the plaintiff and defendant number two to particularly in respect of the clause 8.3 of the said agreement as mentioned in paragraph 8 of the plaintiff.
Then you are bound to ask for specific performance. Without that, the suit is not maintainable. Section 34 specific relief act comes in.
Lord,
you have paid court fees only on declaration and injunction. You cannot get such a declaration without seeking for specific performance of contract. You cannot seek a declaration that they are bound to abide by the agreement without seeking a specific performance of the agreement. Then the effect will be, suppose this decree is passed today on a suit, for eternity there will be a declaration that they are bound to act without you showing your readiness and willingness and without the agreement being performed by you.
My lord, it is a
there cannot be such a declaration.
My lord, this is a loan agreement.
Whatever agreement.
This is the loan agreement.
Whatever agreement. You are seeking a performance of that.
It is the loan agreement by which, my lord, on
cannot seek declaration that any clause of any agreement, decree for declaration, a declaration is a permanent relief. Forever they are then bound. So you cannot get a declaration, simply stated bold declaration that somebody is bound to perform one of the terms of an agreement. If you get that declaration and you never seek for a specific performance, they'll ever be bound by that agreement. They won't be able to transact. They won't be able to go out of that agreement without you seeking a performance of that. So that's an absurdity in itself. So if you claim such a declaration, you have to, the suit is not maintainable. Suit is not maintainable. If not for the grounds given by the trial court, for on other grounds, we can hold that you are not entitled to injunction. What injunction you are asking? That they won't be able to take monthly installment.
Yes.
No, that is also contrary to section 41 of the Specific Relief Act. In effect, you are restraining them from instituting a money claim. You cannot do that.
Money claim, my lord, on what context, my lord?
We'll affirm this order, but on different grounds.
My lord, difficulty is, my lord,
no prima facie.
It is, my lord, kindly have a look to, my lord, the loan agreement by which, my lord, the trial court relied.
We are looking at your reliefs. Mr. Betal, we are looking at your reliefs. You cannot get a relief restraining somebody from taking monthly installments to ECS from plaintiff's account. That means you are seeking an injunction restraining them from making a money claim, which you cannot. They cannot file a money suit today if you get that injunction. And it's barred under the specifically act.
My lord, difficulty is, my lord, the entire, before the project is completed, my lord, the entire money has been, my lord, credited to the account of the developer, and now the developer has paid away. And not only that, the developer is under corporate insolvency under the process. My lord,
then all the more this suit is not maintainable.
My lord, there could have been a prayer.
The relief you are seeking, if he is a corporate debtor and it's under CIRP.
From the pleadings, I find there has been a my lord, question of fraud has been my lord, in the pleadings. In the
Pleadings merely saying fraud does
my
not
lord,
matter.
it is specifically pleaded in the plaint that there is a fraud.
What is the fraud? Where is the particulars of the fraud?
Para 10, page 24. And my lord, it starts from my lord, para 8, page 23.
Sign blank papers. You are a baby, suckling baby. You have signed on blank papers.
And my lord, this is the loan agreement. This is the agreement for sale, terms and conditions.
Loan agreements are always in small print. You enter into them knowing full level.
No, this is the loan. First,
there are fine prints which we don't see. Agreed. But for then, no loan agreement can be.
My lord, the difficulty is, my lord, kindly have a look to para 8. Para 8, my lord, the description, the manner, slabs on which the payment to be made by the bank to the borrower. And the tripartite agreement itself says this, my lord, clause has to be followed. These terms has to be followed. Say, my lord, for construction of foundation work, ground floor, first floor, certain amounts to be, my lord, paid to the borrower, to the developer. But all at a time the money has been, my lord, credited, even if the project has not been completed.
Already credited, then you are not entitled to injunction. What remains for the injunction?
That is why, my lord,
it has been entirely credited. Then how can you get in? What injunction remains?
My lord, kindly see the my lord, page 24. Page 24, clause 9 of the, my lord, schedule.
Yes.
On possession of the flat, 5%. On brick wall of the
page 24.
Page 24 of the, my lord.
Achha, clause 9 on possession of the flat. Yes.
These are the stages. But all on a sudden, my lord, without even the possession, without registration,
Entire amount has been given.
Entire amount.
Now you are seeking an injunction from taking monthly
That is-
installment from you,
that is
your
the-
account.
That is the pleadings of fraud, my lord. That is without getting the property, my lord. Bank, my lord, in collusion with the developer, my lord, they have, my lord, entire amount has been credited. No one is able to stay there. Nothing is there.
Seek for recovery of that amount. Seek for specific performance of the contract. This suit is not maintained as it is. There cannot be a declaration
My lord,
that it is bound by.
one thing I would, my lord, refer. One part of the agreement, one part of the clause has been, my lord, referred. Kindly come to page 158.
Yes.
This is the alleged tripartite agreement. They have, my lord, annexed with the Order 39 Rule 4 application. If the application is no more in the board, my lord, how the trial court can look into this document and came to the conclusion that
Your injunction in application was on the board. It was fixed for hearing.
yes, but
that has been dismissed.
that what the Order 39 Rule 4
Forget
was
the Order
not there.
39 Rule 4. Let the Order 39
Well,
Rule 4
this
be-
document was accompanied with the Order 39 Rule 4. It was not my document. I dispute that document. My lord, kindly have a look.
You have sought for a declaration on this document only. Not
No,
this document.
not
Agreement for sale.
separate agreement for sale.
You say this document is fraudulent.
Is fraudulent not
That
only
will be decided in the suit.
suit, yes, but my lord, kindly come to bottom, my lord.
Yes.
Clause 1, clause 2.
2.
On the condition of the agreement for sale is that the borrower shall pay the sale consideration to the builder as per the schedule of payment described in the agreement for sale. My lord, I have referred agreement for sale.
You say in consideration of parties agreeing to perform their respective obligations. You say they have not performed their obligation.
The builder.
Developer.
Developer.
So, but still payment has been made to them.
In one day, entire money has been credited to the account. Even my concept. And sixth, my lord, the learned trial judge, while deciding this application, relied only on clause 3. And other clauses are there. My lord, clause 5A, next page.
On the date of agreement, it was only CRIT. Company is under CRIT.
Next 5A, the borrower shall bring in or make proportionate amount of his contribution. I paid my contribution.
Please read clause 3.
I understand. But
if you understood, you would not have argued.
My lord,
read clause 3 once.
Yes. the borrower authorities the bank to disburse the home loan directly to the builder, and such disbursements shall be deemed to have been made to the borrower. The borrower agrees not to raise any dispute or objection on the ground that disbursement was not in accordance with the schedule of payments contained in agreement for sale, or not in consonance with the progress of the construction. That means, well, it can be alternatively meaning that, say, second floor has been completed, bank did not
read that with the next sentence.
yes,
please.
the bank has no obligation to verify the progress of construction and has every right to withhold or recall the home loan for non-compliance or
So
default.
therefore, two things read together. One is that you cannot object on the ground that it is
Yes.
not in accordance with the schedule of
Schedule.
payments. Secondly, they have no obligation to verify the progress. So
my
those
lord,
coupled together
my-
do not entitle you to an injunction.
My lord, the harmonious reading, my lord, with the first clause, second clause, with the third clause, and the fifth A clause, the bank has to follow the, my lord, schedule. Because, my lord,
There cannot be any harmonious construction on that, because the other clauses speak about the stages of the construction and all these, your mutual obligation between builder and landowner. We
my lord,
agree.
kindly have a look.
But bank does not have any business to do that.
Clause C, next page, 159.
Yes.
Clause C.
Yes.
The builder shall construct and complete the construction as per the permission and approvals of the agreement for sale within the time frame specified therein. The builder shall submit periodical progress report of the construction developments to the bank. In the event of any delay in construction, developer, for reasons beyond the control of the developer, he shall intimate in writing to the borrower and the bank. These intimations shall be in addition to and without prejudice to rights of the borrower may have against the builder.
But that does not still withhold, permit the bank to withhold the money.
Yes.
Clause 3 remains.
Clause 3 remains, my lord, but there can be two meanings of clause 3. That
what is the other meaning?
Other meaning is that I am in, when the building is completed to say second floor, I am entitled to get the, my lord, the slab payment for, up to the completion of second floor. Bank is not paying. Bank is not paying. In that case, my lord, I have no right. Bank can recall the loan, or and within the time. Even on the date of the agreement, bank was under the developer was under corporate insolvency scheme. And where can we, my lord?
Monthly installment চাইতে পারে কিন্তু lost 3টা রয়ে যাচ্ছে না
The home buyers where will go, my lord? The entire, it is completely fraudulent.
With fully with the home buyer, we can understand your plight.
There are, my lord, guidelines of the Reserve Bank, my lord. I find, my lord, there are.
Yes, what do you say? I mean, aren't you under an obligation, even under this tripartite agreement, to at least to check whether the developer is doing his job?
My lord. My lord, the three things, my lord. Kindly takes page 61 of the application, my lord, which forms a part of the agreement.
Page 62.
There's the inherent lack of jurisdiction, my lord. Clause 18.
This is the tripartite agreement.
But this is the agreement for sale, which my learned friend is imposing on me that I should have acted in pursuance of this agreement.
This is between all three of you?
No.
Developer and him.
The developer and the purchaser. But it has clause 18.
Yes.
There's an alternative dispute resolution.
No, arbitration is not an automatic bar. It is subject to section 8. One can waive that. There's no inherent lack of jurisdiction of the civil court. It's settled now. Arbitration clause, existence of an arbitration clause does not mean that the civil court is not empowered to take up a suit. Civil court can take up, can hear it to the hilt and pass a decree Suppose no section 8 is filed by the defendant.
Yes.
Then definitely, it's not an inherent bar. It's a consent jurisdiction between the parties to the jurisdiction.
It has to be brought to the notice of the court.
Not brought to the notice. Even if brought to the notice, suppose the defendant has a right to waive this section 8. It can submit it to the it's set to the jurisdiction of the court. Here, no such point is taken, but it's not an inherent bar.
My lord.
That is not
my learned friend could have filed a section 9 due to the
could not have. His choice. Till section 8 is filed and allowed, it's his choice. Civil court by default has jurisdiction under section 9 of the CPC. But yes, you are right. If a section 8 is filed and moved properly, court has no other option.
Yes.
If there's a proper agreement. But here that is not the scenario. So this is not an inherent bar. But
the second submission is that the developer, well, it was previously under CIRP. But thereafter it had come out of CIRP. Now it is running its business. Thirdly, well, the account of the plaintiff appellant, well, it became a non-performing asset in 2021. And accordingly, we have initiated action under the RDB Act, my lord. The OA is already filed. And there are orders to that effect. And my lord,
did you point this out in your written objection to the injunction application in the trial court?
No, my lord, I haven't.
Did you file a written objection? Did the bank?
Yes, we have. We have filed it.
Then cannot take into consideration new things. We'll do this. We'll say that
my lord, he is a borrower.
No, 39.4
under section 2, his only recourse against the bank is he has to go before the DRT.
See, in this impugned order, the court did not advert to the merits of the injunction application. Court proceeded on the basis that it has been, some facts have been suppressed and vacated the order. 39.4 was already dismissed previously. We find that from the records.
Yes.
So it could not have been, there could not be a relook at that. 39.4 is gone. Now court has to hear out 39.1.2 on merits.
Well, it has become infractions, my lord.
How?
Well, the account has become NPA.
That you have to point out to the court. Court has to advert to that. That is not the ground on which it has been dismissed.
No, well, that is not the ground taken.
The court has to advert to the injunction application on merits and then decide it. We'll fix a time limit within that. The court will direct the court to, because there are several points you are raising which you are also entitled to raise there.
Yes.
So that will be precluding you from taking these points also. So we'll permit you to, we'll direct the court to dispose of the injunction application within 4 weeks from communication. And we'll say that this 39.1.4 will not go into the merits at all. Because court trial will preclude, then usurp the jurisdiction of the court.
Yes.
Both of you will be losing a forum. We'll vacate this order, we'll set aside this order, because there was an ad interim injunction, 39.4 has been rejected, that ad interim injunction has to continue. 39.4 has been rejected, ad interim injunction revives.
And then by the impugned order, the order
39.2
has also been rejected.
That we find that's palpably contrary to law, because it has not been adverted. None of the merits have been.
It has been heard. It was for orders. It
heard
was for orders.
Yes, but where is the reasoning, sir? Where is the reasoning on the injunction application? Show us one line of reasoning. Apart from this, on perusal of the agreement.
Suppression.
Number 1, paid the entire. Suppression is on 39.4. 39.4, there was good ground, but that was rejected previously. No restoration. The present appeal has been preferred against an order whereby an application under Order 39 Rule 4, that 39.4 was filed by you or the...
Yes,
39, an application under Order 39 Rule 4 of the Code of Civil Procedure filed by the respondent number 1-bank was allowed, thereby vacating an ad interim order of injunction granted earlier on the ground of suppression of material facts and dismissing the main application of the plaintiff stroke appellants under Order 39 Rule 1 and 2 itself. For some next parallel, counsel for the appellant places reliance on the order sheet in the suit
197,
wherefrom it is evident that by a previous order bearing order number 34 dated October 17, 2023, the self-same application under Order 39 Rule 4 of the Code had been dismissed for default since none had moved the matter. Hence, the principle of Order 9 Rule 9 is applicable, and in the absence of any application to restore the said vacating application, there could not the self-same application for vacating under Order 39 Rule 4 of the Code could not have been revisited by the learned trial judge, comma, after the same was dismissed for default previously. Full stop. Thus, comma, the portion of the impugned order whereby the order ad interim order of injunction was vacated, comma, it is argued, comma, is bad in law. Full stop. It is also submitted that the plaintiff's appellants have taken the ground of fraud insofar as the tripartite agreement between the parties is concerned. Full stop. Unless such issue is decided, comma, the same cannot be given effect to. Full stop. It is further submitted that there was a collusion between the respondent number 1 bank and the other respondent stroke developers against the appellants, comma, insofar as the appellants stroke home buyers were duped, D-U-P-E-D, duped by the developer not performing their part, their developers not performing their part of the agreement, development agreement, of the agreement with the appellants, but at the same time, comma, the bank, respondent number 1 bank, disbursing the monthly installments in favor of the defendant number 1 from the plaintiff's account. Full stop. Next para. Learned counsel appearing for the respondent number 1 bank submits that the trial court did not have inherent jurisdiction to take up the suit in view of the arbitration clause bearing clause number 18 in the agreement between the developers and the plaintiff stroke appellants. Full stop. That apart, comma, learned counsel for the bank submits that subsequently the account of the present appellants has been marked as non-performing asset within bracket NPA, and proceeding has been initiated under the debts recovery.
Yes, sir. Before the debts recovery tribunal.
Before the debts recovery tribunal, comma, which is now pending. Full stop. Next para. Be that as it may, comma, we find from the impugned order that the entire.
May I just indicate one thing, my lord?
Yes.
On record, my lord. Page 200, my lord. There are 2 more orders.
This was restored, Order 39 before?
No. But it was not restored, but my lord, it's written that for hearing of the petition under Order 39 Rule 1 and 2 and Order 39 Rule 4 of the CPC.
That was wrong.
And my lord, subsequently, again on the next date also, it was, my lord, recorded.
Yes, there the mistake started apparently.
Yes, my lord. But these orders, my lord, were not challenged.
Need not. All orders passed in a dispose of matter are nullity. That internal, that the substantial portion of the same is dedicated to the application under Order 39 Rule 4 of the Code of Civil Procedure, which had already been dismissed. Full stop. Although learned counsel for the respondent number 1 bank points out that subsequent to the order of dismissal for default of the Order 39 Rule 4 application dated October 17, 2023, comma, the trial court had recorded that the said application was fixed for hearing, comma, those orders need not have been challenged separately, comma, since any order passed in an already dismissed application are nothing but a nullity and do not have any force in the eye of law. Full stop. Next para. Although the learned trial judge might or might not have been justified in vacating the interim order, ad interim order on the ground of suppression otherwise, comma, we desist from commenting on the merits of the said application, comma, since the impugned order is palpably vitiated inasmuch as an application for vacating which had earlier been dismissed for default was revived without any prayer for the same and was allowed thereby. Full stop. Next para. Insofar as the main application for injunction under Order 39 Rule 1 and 2 is concerned, comma, the learned trial judge did not advert to the rival contentions of the parties on merits on the same, as is clear from the reasoning in the impugned order. Full stop. Next para. The learned trial judge proceeded to vacate the ad interim order on the ground of suppression and apparently, comma, as a consequence, as recorded in the order itself, dismiss the main application for injunction under Order 39, Rules 1 and 2 of the Code. For the next para, however, such approach is diametrically contrary to law, since the considerations in passing an ad interim order or vacating the same are entirely different than that while disposing of finally an application for injunction, the main application for injunction on merits. Full stop. In spite of an ad interim order being either granted, refused, or vacated, the court, while disposing of the main application for injunction, has to independently advert to the rival contentions of the parties and go through the materials on record before it for adjudicating the same. Full stop. Such an exercise is completely different and separate from the considerations applied to an ad interim order. Full stop. Thus, the learned trial judge erred in law in dismissing the main injunction application as a mere consequence of vacating of the ad interim order without independently deciding the same on merits. Full stop. Accordingly, FMAT 345 of 2025 is admitted and allowed, thereby setting aside the impugned order bearing order number 42 dated April 8, 2025, passed by the learned fifth bench, by the learned judge, fifth bench, City Civil Court at Calcutta, in title suit number 1063 of 2020, and directing the learned trial judge to rehear on merits and dispose of the main injunction application under Order 39, Rules 1 and 2 of the Code of Civil Procedure, independently on its own merits, as expeditiously as possible, preferably within 6 weeks from the date of communication of this order to the learned trial judge. No arrest to cost. Acha, consequentially, can one was this section 5?
Two, my lord.
One was
one
section 5.
Consequentially,
can 2 of 2025 is also disposed of, no arrest to cost. Urgent certificate copies. Next.
Deep coverage.
Yes. Thank you.
That will matter.
You have corrected the.
Yes, yes.
Very.
Two corrections made.
Yes.
My lord, with regard to my lord, the name, there was a dispute, my lord. My lord, in the applications is mentioned as Swati. It would be my lord Shanti. My lord, kindly, my lord, gives us the leave.
He had given you the leave on the last.
My lord, for this one, my lord, your lordship said to inquire from our client, and my lord, come back and report.
Oh, leave is granted to the learned advocate and record for the appellants to carry out the necessary corrections regarding the name of the performer respondent number 4. Or no?
Respondent number 1.
Name of whom? Which respondent?
1. Respondent number 1.
Respondent number 1.
1.
What have you written here? Srimati Shekhar Das, son of. You have already corrected.
The lordship is looking at the memo.
No, application for stay. Shekhar Das, son of Srimati Shekhar Das. What is this?
Application for state. T, my lord, is Swati.
There is no Swati in our. This is Bharati Das versus Shekhar Das.
Bharati Das, my lord.
There is no Swati here.
My lord, what happened, my lord, was in the memorandum of appeal, Shekhar Das was mentioned. Well, subsequently, it came to the my lord.
Please carry out the corrections. We gave you the liberty yesterday.
My lord, the
liberty is granted to the learned advocate on record for the appellant to carry out all necessary corrections to the cause titles of the applications and the memorandum of appeal. First of all, let the matter be stand adjourned till tomorrow. Please do that during the course of the day. We'll take up the next matter after we come back.
আমি তো কালকে যেটা
Appeal because there is no defect. We are fed up with this defect. Every matter defect, lawyer doesn't know what is the defect.
I guess little too early because Millards were pleased to permit me to file a supplementary affidavit. Now that has been filed in the department.
In your case?
Yes.
Excellent. You want to delay the matter?
No, I don't.
So it cancels out that non-delay.
So I said it was a little too early. So Millard, the plaintiffs in a suit for declaration, injunction, recovery, possession is the appellant, Millard. Millard, declaration to the effect, Millard.
Or is for the other side?
Yes. I'm led by Mr.
Millard, declaration supplementary affidavit copy
Declaration of
declaration Millard, to the effect that Millard, the title deeds by virtue of which Millard, the defendant number one claims title to the property are void. And Millard, the other declaration is that the development agreement, Millard, by virtue of which Millard, the defendant number one permits the defendant number two to develop the property is consequentially void. So Millard, these are the two declarations, Millard, and recovery possession because
sorry, the first one is which deed is void?
Millard, the deeds by virtue of which Millard, the defendants claim title to the property.
The
Defendant number one.
have title, therefore they can't give a
Yes.
development.
See that,
Who are you?
Millard, I am the owner. I say I am the owner of the property.
You had executed property.
No. I say, Millard, that the predecessor in interest of the defendant number one, the deeds that were executed by the predecessor in interest of the defendant number one in favor of defendant number one were null and void because the predecessor in interest of defendant number one did not have right title interest to Millard to sell or convey this property.
But how do you claim title?
Millard, I claim title by virtue of a deed of the year 1967 in favor of my father, who adopted me.
By whom? Defendant number one's predecessor?
No. By someone else. So it's a question of dispute, title dispute, Millard. And recovery possession, Millard, thereafter, since constructions are being carried out. Millard, in such a suit, Millard, I took out an application for injunction, restraining, Millard, the construction that is being carried out by the developer, Millard, on the said land. Now, my application for injunction is rejected by the impugned order, Millard, contested.
You have to secure the losses which may be suffered by them if ultimately.
Millard, I am not the developer. I am the owner of the land.
Yes, but you're seeking injunction. You're restraining them from. I mean, they're developing a property.
Millard, what has been done is, Millard,
this venture.
Millard, what has been done, Millard, is the learned judge in the court below permits them to continue construction.
So what is the difficulty in that?
Millard, kindly visualizes. Then, Millard,
they've already started construction. You
Yes,
cannot revert it back to scratch.
No, Millard, then what happens?
It will abide by the result of the.
Then what happens is, Millard, they are also permitted to create third-party interests.
That is what development is about, also.
Yes, Millard. But then what happens is, Millard, he says, the learned judge in the court below says that the defendants cannot claim any equitable relief in the suit is decided in favor of the plaintiff, the defendants, not third parties. Millard, if they're selling the property, Millard, third-party interests are being created, Millard. Then, Millard,
let us see that.
Kindly seize the impugned order, Millard.
Yes.
Millard, this is subject to correction, Millard, borrowed the wisdom of the Supreme Court 2008.
Which you say was not wise.
No. He should have followed it in its entirety.
Let's see how
Millard, seize the impugned order, Millard, annexed to this, Millard, the memorandum of appeal, Millard. Millard, the operative portion would be, Millard.
You have not given the name of the judge. That's a defect, not pointed out in the preamble. That is the first ground of.
It was really too early. No, Millard, I was correct. It was too early, Millard.
So we'll grant you leave. Do that even if you lose the order button, then
we'll still do it.
At a line, leave is granted to the learned advocate and court for the appellant to insert the name of the learned trial judge in the preamble of the memorandum of appeal during the course of the day. Please take information somebody from your counterpart and yes, please continue.
In connection with the appeal, we have taken out two applications, Millard. One is an application for injunction and the other is an application under order 4127, Millard. Now kindly seize, Millard, the impugned order, the operative portion, Millard. It starts, Millard, after discussions, Millard, the penultimate page of the Millard, the impugned order, Millard.
Yes. You can start from the second page, peruse the entire order after that.
Peruse the entire record. It is fact that the plaintiff has filed this suit through a constituted attorney, namely such and such, but has not filed any document in respect. That we have, my lord, by order 41, we have sought to annex that document. Yes, my lord. The single document on which the plaintiff has relied upon at this stage is a title deed in the name of N.S. Chaudhary for the year 1967. It appears from the deed that N.S. Chaudhary had purchased the area of 9 kata 5 chitaks from plot number 75 under Khotian number such and such. In the recital of the deed, it appears that there was the existence of a single-story house consisting of 3 rooms. Plaintiff has claimed her title in the suit property on the strength of the sale deed executed in favor of N.S. Chaudhary in the year 1967, and also on her claim that she is the adopted daughter of N.S. Chaudhary. However, not a single scrap of paper has been produced by the plaintiff to show her prima facie claim of adoption by N.S. Chaudhary. In the absence of any documents showing her as an adoptive daughter, she cannot substantiate her prima facie claim of having title in the property mentioned in the sale deed being such and such. These documents, my lord, also annexed in the order 41, 27 application.
Why didn't you produce them in the court?
It was not produced, my lord. It was not produced.
That is the premise of your case.
My lord, kindly.
You claim through N.S. Chaudhary.
But my lord, the learned judge in the court below holds that I have a prima facie case. Holds I have a prima facie case.
Yes.
My lord, kindly, my lord. Apart from the title deed, no other document regarding possession of N.S. Chaudhary or the plaintiff has been filed since 1967. Moreover, no document has come before the court to satisfy that the property which was sold out in favor of N.S. Chaudhary in the year 1967 is actually the suit property and the subject matter of the dispute. Therefore, only on the basis of a sale deed for the year 1967, plaintiff has
That sale deed was produced.
That sale deed was produced.
But what does he mean by saying is actually the suit property? The addresses vary.
I'm not very sure, but that deed was there.
Maybe
It's a totally different property on which the construction is made. That is the case.
Well, kindly seize the reasonings then. The plaintiff has come before the prayer for temporary injunction, which is the purchase of suit property by dint of 2 registered sale deeds of the year 16 from R.S. Chaudhary. Now, therefore, R.S. Chaudhary has purchased the suit property in the year 2008 and 13 from Kalu Khan, son of Bhudev Khan, and Bhudev Khan, as appearing in the R.S. ROR, was the recorded owner of plot number such and such. Kalu had sold out the properties from R.S. Khotian number such and such, which is produced before this court. Plaintiff has challenged the execution of the deeds for the year 2008, 13, and 16. Learned advocate for the defendant has also challenged the contention of plaintiff in this respect on the ground of limitation. Now, defendant number 1 has executed registered development agreements and registered power of attorney with defendant number 2 since the year 2022. 22 defendants have also filed documents in support of the fact that after the purchase, the suit property was recorded by in LRROR in the name of defendant number 1. The suit property was also converted the nature of commercial bastu in the year 2023 on the prayer of defendant number 1. Defendant number 1 had also taken development permission for commercial housing project from Asansol Durgapur Development Authority. West Bengal Real Estate Regulatory Authority had also issued registration certificate for development of the project. Plaintiff has also taken permission from the West Bengal Fire and Emergency Services for the construction of the project. Asansol Municipal Corporation had also given a building permit in favor of defendant number 1 by sanctioning the building plan. In the premises, it can be inferred that defendant number 1 had entered into a development agreement with the defendant number 2 and exhausted all statutory formalities and taken approvals from competent authorities, which are prerequisites for entering into a real estate construction project. The actual parties against whom plaintiff has grievances are not made parties in the suit. The plaintiff has challenged the legality of sale deeds in the name of R.S. Chaudhary on the ground that Kalu Khan had no existing title to transfer the property, so plaintiff should have made them a party in the suit. Defendant number 1 presumably could not have any acquaintance or personal knowledge about the deeds which were executed in favor of the vendor. As per the plain case, plaintiff was aware of the fact that this property in dispute was owned by adopted father N.S. Chaudhary since 1967, and the father expired in the year 2001. In between 1967 to 2001, N.S. Chaudhary did not make any endeavor to record his name in record of rights, nor pay taxes against the property. After 2001, plaintiff did not consider it important to inquire about the property and take initiative to up to date all documents relating to the property. She became alert only in the year 2025 after getting information of stocking of building materials in the property. It is her own averment that she visits India regularly, and as per her claim, she being the sole legal heir of the father ought to have taken care of all assets of her father. In that case, the prudent conduct will be to discharge all statutory liabilities relating to the property and to procure all relevant documents from the competent authority in her own name. Surprisingly, conduct of the plaintiff is way beyond the normal human conduct of a prudent person, and such fact raises doubt in mind. Then, Mullet, principles grant of injunction have been discussed, Mullet. Then, Mullet, in this suit in hand, plaintiff has brought forth an arguable case which cannot be settled in the absence of trial. So there's a prima facie case which requires the court's interference. In the context of second cardinal principle of defendant number 1 had purchased the property in dispute in the year 2016 and had taken possession of the same both physically and through documents. Defendant number 1 had already executed a considerable portion of the building after exhausting all required formalities. In pursuance of the commercial venture, defendants have taken loan from the bank and has also received part consideration from prospective buyers. Therefore, while weighing the potential harm to both the parties, it is found that the defendants will suffer more inconvenience or damage if the injunction is granted. Defendants will not only suffer huge financial loss, but they'll also be damaged to their reputation and goodwill, which they have earned through passage of time. On the contrary, plaintiff has already initiated this suit for recovery of possession and has also sought for declaration with reference to the impugned deeds. Defendant or any lawyer or a buyer, a buyer accruing title through defendant will have to be a consequence of outcome of the suit. Neither defendants nor the subsequent buyers can evade the decision derived by this court after contested trial. The judgment of the court suit will be binding on defendants and each and every person who will step into the shoes of defendant. Therefore, considering all aspects in view of the first discussions, I am not inclined to grant an order of temporary injunction, as balance of convenience and inconvenience is not lying in favor of plaintiff. Therefore, ordered, Mullet. Defend petition such as rejected. Defendants cannot claim any equitable relief in case the suit is decided in favor of the plaintiff. Defendants are directed to notify the prospective buyers regarding pendency of the suit, and they will be bound by the decree.
This is sufficient protection.
Mullet, kindly visualize it.
Notify the prospective buyers is sufficient. We could not have given more.
Mullet, kindly visualize.
Balance of convenience definitely.
Mullet, may I put this, Mullet? Now, third-party interests.
This is a very good order, very balanced order. And we have seen very few orders on balance of convenience like this one. In one paragraph, he or she has done a very good job.
2008, volume 11, page 1.
11 SCC, page?
2008, 11 SCC, page 1. Is the judgment which, I believe, reliance has been placed upon by the learned judge in the court below. May I hand over?
Yes. You have to read from somewhere then. You don't. We have this.
Paragraph.
No, it's
26.
Eta Feruddin.
টাচ করে দিন, হ্যাঁ স্ক্রিনটা টাচটা দিন,
টাচ করে রাখুন না আমাদের yes
Mullet, kindly seize Mullet para 26 and 27. This is what I believe reliance has been placed. But more or less similar set of facts, only there, Mullet, it was a suit for partition when admittedly one of the co-sharers had some semblance of right on the property. But they
have a semblance of right. They have a deed. You have not.
But we are disputing that. That's open. That's being disputed, Mullet. We dispute that. Yes, Mullet.
But
at his prima facie phase, what my lord says, at the prima facie stage, Mullet, there's something in their favor. Mullet, kindly seize. Rightly or wrongly, constructions have come up. They cannot be directed to be demolished, at least at this stage. Respondent number 7, who is the developer, Mullet, has spent 3 crores of rupees. If that be so opinion, it would not proper to stop further construction. We are therefore of the opinion that interest of justice would be subserved if, while allowing the respondents to carry out construction of the buildings, the same is made subject to ultimate decision of the suit. Precisely what has been done. The trial court requested to hear out and dispose of the suit as early as possible. If any third-party interest is created upon completion of constructions, the deeds in question shall clearly stipulate that the matter is sub judice and all sales shall be subject to the ultimate decision of the suit. All parties must cooperate in the early hearing and disposal of a suit. The respondents must also furnish security before the learned trial judge within 4 weeks. Now, my lord, here's my lord, what we say, my lord. If, my lord, the defendant number 2 is permitted to raise constructions, my lord, and eventually, if the suit is decreed in my favor, my lord, then, my lord, there will be multiplicity proceedings. For that, my lord, they should be put on security, my lord. Security ought to have been, my lord, should have been directed to put in security. Number 1, my lord, and number 2, my lord, the sale deeds, if, my lord, such sales are being permitted, my lord, the order must contain that the sale deeds must contain this clause, and that must be, my lord, after ratification by the court concerned. Because in the event, my lord, the sale deeds do not contain this clause, the third party might come to court and say that they are not bound by this order insofar as only the operative portion says that the defendants cannot claim any equitable relief.
Why would section 52 not apply? Because in a specific performance suit, yes, bona fide purchaser for value without notice is protected. But in a normal suit, section 52 is applicable.
Mulad, but here, Mulad, there is an order by the court which says only the defendants are cannot claim equitable relief.
We cannot bind third parties who are not parties to the suit.
Well, precisely so, Mulad, I say, Mulad, if any...
Put in this right and notify the prospective buyers, you say that should be with the sanction of the court every time.
Yes. And that clause must be embedded, Mulad, in the sale deeds that are being, being executed. And that apart, Mulad.
Yes.
And that apart, Mulad, is question of security.
Why security? We don't understand the logic of this.
Mulad, kindly visualize, Mulad. In the event, Mulad, the suit is eventually decided in my favor, Mulad. What happens? There's a building which has come up, Mulad.
Third parties have been inducted.
Inducted, Mulad. So, Mulad, the security has to be there, Mulad. In fact, Mulad, there's a 2010 judgment of the Supreme Court on similar lines, which Mulad says that you can raise constructions, but you cannot create third-party interests. This is one step further. You can create third-party interests, but subject to these conditions. And that apart, Mulad, I say that the defendants, Mulad, do not have any semblance of right in the property. At least that's what our case is.
Much more semblance of a right than
Mulad, that
only thing is that 1967 deed is earlier.
Yes. That's what
the adoptive daughter thing also, because whether Kalu Sheikh or those people, their vendors could have acquired right.
I bow down, Mulad, and Mulad, the question of adoption, Mulad, has been admitted by the defendant in a separate suit. The plaintiff, whereof we have already annexed in order 4127 application. They have admitted that the adoption, there's no question of adoption. The adoption is Mulad, sacrosanct.
Let us see your order for 27 now. Your adoption regarding the adoption and the other plaint also you must have annexed.
Mulad, kindly sees the order 4127 application.
Page 23.
Page 23 onwards, Mulad.
This is Can 2. Yes.
Can 2.
Page 23 is the plaint of the other suit.
Yes, Mulad.
Admission of adoption.
Yes, Mulad, kindly sees that. Gurbinder Singh Chaudhary.
You are
Mulad, I'm Bhavna Uppal, defendant out there, Mulad. Kindly sees the plaintiff, Gurbinder Singh Chaudhary, son of R.S. Chaudhary. Mulad, R.S. Chaudhary is the predecessor in interest of the defendant number 1 in this suit.
Yes.
So, Mulad, Gurbinder Singh Chaudhary is the son of R.S. Chaudhary. Mulad kindly comes and takes, Mulad, page 23, 25, Mulad, the last, Mulad, 3 lines. Page 25, Mulad. Mulad, may I place the last paragraph at page 25, Mulad. The wife of Rajendra Singh Chaudhary, that is Manjit Kaur Bewa, predeceased her husband, and both Rajendra Singh Chaudhary and Manjit Kaur Bewa died, leaving 2 sons, plaintiff and the proforma defendant. And though the defendant is the natural born daughter of deceased Rajendra Singh Chaudhary and Manjit Kaur Bewa, but she was adopted by N.S. Chaudhary and Meera Chaudhary, as Narendra Singh Chaudhary and his wife Meera Chaudhary had no issue of their own. They adopted the defendant Bhavna Uppal as their daughter, and all the rituals of adopting, including giving and taking ceremonies, were duly performed in presence of relatives and friends of both the families.
How are Narendra Singh Chaudhary and
Brothers, Millet. Narendra and R.S. Chaudhary.
brothers.
So, Millet, the question of adoption has been admitted.
Their predecessor was R.S.
Yes.
So his son admits this.
His son admits that the
That's not
adoption is
binding
valid.
on them directly, because if RS admitted, then we could have understood.
But Millet, he's claiming through RS, Millet. So Millet, I appreciate what could eventually fall, that these are issues to be gone in the time of trial.
No, that's different. But whether you have a strong prima facie case. Saying in a deal, somebody saying in a plaintiff when you are adopted, I mean, something
Millet, against me, Millet, in a suit institute against
something
me.
has to be there. I mean, some dattamam, something, some.
Millet, they say that all rituals of adopting, including giving and taking ceremonies, were duly performed. Millet, R.S. Chaudhary's son says that.
RS's son says.
His son says that.
RS, for all that we know, RS might not have been aware of the pro forma. He was,
Pro forma.
No.
Millet, the suit is
Pro forma was another son of RS.
Yes. So RS, Millet, RS's son sues. The other son is the performer.
Son may be at loggerheads with his father. We don't know. For all that we know. This is not an admission by RS.
No, Millet, he's son of RS, Millet.
Son of RS may be at loggerheads with RS. We don't know. Sons of RS are parties.
Both the sons, Millet. One is the plaintiff, the other is the Millet.
For injunction, maybe we don't need conclusive proof.
At least prima facie, Millet, the adoption is sacrosanct.
Very well. Balance of convenience still remains. I mean,
but
they have to say either they require permission of court every time, they have to have the deed sanctioned, or
and put security, Millet.
And put security.
And Amar documented father's name has been shown as including the passport.
No, that's and all the other documents that have annexed to order for 27 Millet shows my father's name as Millet NS,
including the passport.
The adoptive father.
Your documents.
Yes,
injunction application.
Kindly seize my injunction application can 1 Millet. Page 60.
Documents which are not in the
but I have sought to
the injunction application was disposed of in the trial.
Yes.
So you had the opportunity, not at the ad interim stage.
No, not at the ad interim stage.
Then documents we cannot look into actually. We can look into ad interim, yes.
Order 41, order 41/27 is an application to the effect.
Has its limits in an appeal against an interim order. I mean, it's not a regular appeal.
No, it's always discretion of the court.
It was available to all of these.
Available.
Then why not order 41/27 AA comes in?
But if that is essential for the court to pronounce judgment, B comes in.
Then A will be overridden by that.
No,
It's not so essential.
I don't say that. I don't say that.
If this was the only document on which everything turns, then these are your documents you had to prove. You could not prove. That was the ground.
Those documents were not produced.
Okay, let us hear Mr. Kaur then. Yes, Mr. Kaur. Mr. Kaur, what about this 1967 deed?
I'll just take 2 minutes of your lordship's time. Lord, we have acquired the title in respect of 6.5 kathas of land from R.S. Chaudhary, who is plaintiff's biological father.
Yes.
Now, Lord, he claims that she was adopted by N.S. Chaudhary, the brother of R.S. Chaudhary. And this N.S. Chaudhary had purchased a so-called property of in 1967. Now, I'll show your lordships the two schedules.
Different.
Lord, that looking at the schedule, your lordships will understand, and that's why the learned judge has rightly observed. Your lordships will find he says that apart from the title deed, no other document regarding possession of N.S. Chaudhary or plaintiff has been filed since 1967. Moreover, no document has come before this court to satisfy that the property which was sold out in favor of N.S. Chaudhary in the year 1967 is actually the suit property. So, my lord, this is prima facie finding. Lord, a person who has filed a suit seeking declaration of title, he has prima facie, the court has come to a finding that he has not been able to show his prima facie right over the property.
Now, Lord, let us see the plaint. Lord, what is he challenging? He is alleging that his father's purchase was a fraud. That he is saying that the father never acquired title because the purchase of father from that Bhudev Khan and Kalu Khan was fraud. And therefore, she is seeking a declaration that that title deed goes. Your lordships, kindly have a look at the plaint. Starts at page 40
of Can 1.
Can 1. Please come to paragraph 3. That unfortunately, late N.S. Chaudhary passed away on 20th September and his wife, late so-and-so. Upon their demise, the present plaintiff, being the sole legal heir of successor, inherited all movable, immovable properties, assets left behind by them, including the suit property. It is respectfully submitted that late N.S. Chaudhary and late so-and-so had no biological children and had legally adopted the plaintiff, who is the biological daughter of Rajinder Singh Chaudhary, the brother of late N.S. Chaudhary. It is also pertinent to mention that Sri Rajinder Singh Chaudhary had 3 children, namely Bhavana Uppal.
Yes, we have seen also paragraph 4 also we have seen
Paragraph
graphically stated.
Graphically stated.
Yes.
Then
out of greed and taking undue advantage.
Yes, and your lordships will find that, Lord, then the sale deeds by which her father acquired, they are, Lord, set
challenging
4.5 kathas, and then, Lord, 2 kathas. Your lordships will find, and ultimately, after this, your lordships will kindly take paragraph 12. Your lordships will find that he is seeking declaration of cancellation of those deeds of her father also.
Yes.
And Lord, kindly see the prayers. Your lordships will find that he is not only seeking cancellation of my document, but also seeking cancellation of her father's Lord, title in respect of this property.
It's because you claim through her father.
Obviously, Lord, it has come now. Now, Lord,
because they say that no transferable title was available with Rajinder Singh.
Right.
Because of the 1967.
That there has to be, then, Lord, the pleading should have been that the property which they had purchased, his father had purchased, was the same property which was held by N.S. Chaudhary. Your lordships would not find that pleading.
But they say that they have, N.S. Chaudhary had rights in the suit property itself.
Kindly come to Lord, that 1 second.
Yes, para 3 they state.
Yes.
NS and Mira, upon their demise, present plaintiff being sole inherited all movable, immovable properties
of NS,
including the suit property.
Yes,
they say that in para 3, including the suit property. And these deeds are also regarding suit property.
Correct, Lord. Now, kindly
as per their allegation.
Kindly see, Lord, the schedule to the property. Kindly see the schedule.
Yes.
Lord, kindly see schedule. It says out of aforesaid land within Asansol. Kindly come to about 4 lines from the top. It says out of the aforesaid land within Asansol municipality under CS Khatian number such and such, an area measuring such and such, 9 kata 5 chataks are occupied by a single storied structure comprising of 3 rooms, 1 veranda. The total built up area of the room measures approximately such and such. Adjoining the northern boundary of veranda, a vacant strip of land measuring 15 feet in width, falling under CS plot number 7576, constitute a private road leading to Burnpur Road.
This entire thing from 1.005 onwards.
Now, Lord, this private road, which is to the property which leads to the Burnpur Road, there is no private road so far as we are concerned leading to Burnpur Road. We are far away from Burnpur Road. We are on GT Road. Look, we are on GT Road. It's far away from the Burnpur Road. Number 1. Number 2, kindly see, Lord, the document just Lord, kindly see, Lord, this schedule, this talks about a Khatian. your lordships will find that it says Khatian number, CS Khatian number 157.
Yes.
Number document ROR. The record of right, which is Lord, part of the record before the learned trial court. Kindly, Lord, have a look at this ROR, record of right. এটা কোথায় গেল? হ্যাঁ, এটা দাও, আরেকটা কপি, আরেকটা দিচ্ছি, আরেকটা কপি দাও। This record of right has been taken note of by the learned judge, my lord. Kindly have a look at the record of right.
This is Khatian number 151.
151.
151.
No, this is Khatian number 436. Your lordships will find it was originally 209 at the top. Lord, at the top.
Achha, 209.
Which is now, my lord, 436. Has your lordship?
436.
It is 209 is struck off by pencil and
436, yes.
And my lord, kindly see now, Rayati is Bhudev Khan. Has your lordship found that?
Yes.
Bhudev Khan. Then, lord, please see the next page.
This
Dag
is
number.
CS. This is CS.
Yes. Dag number 315, 316, 317. হ্যাঁ, বই পড়েছিল এই তো এখানে।
This is a CS record. This is probably not the CS record.
This is not the present Khatian. This is the present Khatian. এটা এখানে। Lord, please come to the order once again.
Are both the sale deeds before the trial court?
Yes,
their sale deed and your sale deed?
Yes.
The schedules, comparison of schedules.
Kindly have a look at our schedule. আমাদের document
Their sale deed must contain this schedule.
Their sale deed.
We can look at your sale deed.
Yes.
Your purchase deed rather. RSS purchase is or your.
আমাদের document দাও। I'll just give it. আমাদের convenience দাও। Page টা বল। They have disclosed it in the supplementary to Can 2. Page 57. Page 7.
59, page 73 of session.
What is this original supplementary affidavit?
But there are two supplementary affidavits
No,
perhaps.
there are two supplementary affidavits. On last occasion, there was a prayer made.
Both are original supplementary affidavits.
Both are supplementary.
Please come to page
For
7.
two applications.
Both are original supplementary affidavits, not only supplementary. You have stated that.
The document starts at
The thinner one or the thicker one?
the thicker one. Document starts at page 60. Huh? No, 61. Kindly starts at page 61.
Where is the schedule?
Schedule is at page 72.
Within 436. This is probably RS. This deed.
Let the RS number and CS number.
RS.
RS. It may be different, but then they have to plead something.
That Khatian number has to tally.
Tally and they have to plead something that those are said. They are saying although that it's
merely saying that I have inherited is not sufficient. That has to be in some letter and spirit. It has to be shown.
substantiated, yes.
And moreover, my lord,
It has been substantiated in spirit.
the learned judge also records that, my lord, post purchase, no steps have been taken, no property tax is
Yes,
paid.
nothing done.
Nothing has been done. And my lord,
That does
only
not
when
disentitle them of title. I mean, their cause of action is you are making construction, so they came.
the whole cause of action started after I started making construction.
So I mean, they might not have asserted any right, but they still don't lose the right title in the
But
property.
if they have a right, that right they have to establish in a proper trial. Today, my lord, I have completed 90% of the building.
But if they win the suit ultimately by
But they are entitled to compensation. Damages, they will
so
be
therefore
entitled.
the question of security comes in then as per the
Lord,
Supreme Court.
the question of security
By you.
when the claim is in damages, Lord, question of there, Lord, the title was established. There was a co-owner. Here, Lord, the title is yet to be established. Lord, one has to show a prima facie case. Today, I am saying that there is no remote case also.
Very.
And in fact, Lord, this has been taken note of, that LOR, the record of right, your Lordship will put it in the order. It says that Chaudhary had purchased the property in the year 2008 and 13 from Kalu Khan, son of Bhudev Khan, and Bhudev Khan is appearing in RS ROR. Kindly see the third page, Lord, at the top.
Yes.
The court records that suit property by dint of two registered sale deeds of 2016 from RS Chaudhary. RS Chaudhary had purchased the property in the year 2008 and 13 from Kalu Khan, son of Bhudev Khan, and Bhudev Khan, as appearing at RS ROR, was the recorded owner of plot 315, 316, 317 and 340. And this is what the record of right shows. Kalu Khan had sold out the properties of RS Khatia number 436, which is produced before this court. Plaintiff has challenged the execution of the deeds for the year 2008, 13 and 16. Her own father's document is also challenged. Learned advocate for the defendant had also challenged the contention of plaintiff in respect of the ground of limitation. Now the defendant one has executed registered development agreement. So, my lord, when she sees that a property is being constructed, a multi-storied building is being constructed with all the permissions that I have obtained, Lord, for the purpose of obtaining the sanction plan, under the municipal law, Lord, also, I have to show that I have title to the property. I have obtained, Lord, sanction plan, Lord, from the Asansol municipality. I have obtained.
That is on the basis of a sale deeds.
NOC or
Have
from
sale deeds, they don't deny that. They're challenging those.
Fire service. And then the land has been converted into commercial, Lord, Vastu. That is also.
You've invested also on that.
I have invested, Lord.
You've got everything. Your names have been recorded, conversion has been done, permissions have been obtained.
Therefore, Lord, in so far as the order is concerned, in fact, I thought, Lord, the order runs a little contradictory from the end part with the front part. In the front part, your Lordship sees that the court records that there was not a scrap of paper which could be produced to show that she is an adopted daughter, she has inherited. And then, Lord, it says that there is no document to identify the property. After all this, then, Lord, suddenly the court feels that there is a tribal issue, and so, Lord, apparently there is a contradiction between the front portion of the finding and the later portion of the finding. Maybe the court wanted to give them some right, that's another thing. But, Lord, I intend to, Lord, file a cross objection. In case, Lord, your Lordship admits the appeal, obviously, Lord,
that is sufficient threat.
No. If the appeal is not admitted, then, Lord, I have to file an independent appeal. But in my opinion, Lord, this second part of the order, which protects them by saying that I have to insert that clause in the document, that also is something which they have got, Lord, which
they
didn't have. That
yes, Mr. Borden, what is your argument? Yes, Mr. Borden.
Two things, my lord. Kindly seize, my lord, the impugned order, the third last.
Do not tally.
The third last page, my lord. It says the judge in the court below proceeds as if.
May I have my lord's kind leave?
Yes, sir.
Proceeds as if the development agreement was entered into in the year 2022. Kindly seize, my lord, the impugned order, my lord. The third page of the impugned order. Defendant 1 has executed registered development agreements, registered power of attorney with defendant number 2 since the year 2022. मतलब supplementary affidavit मतलब to a can कौन था one can two मतलब sees मतलब the first annexure at page 9.
What does it say?
The development agreement was executed on 13 November 2024.
And you filed the suit on
2025. I filed it sometime in the month of April. And Mulot, kindly visualize this aspect. Mulot, the plaintiff does
already started construction.
Yes,
They've already made substantial construction. Balance of confidence is definitely against you.
kindly visualize this thing. Mulot, I am a person who is not staying in India. I have a power of attorney holder. Mulot, no qualms on that score. If Mulot says that I should have been more vigilant and approached the court at an early instance, Mulot, I might not have something to say about it. But the fact remains, the development agreement is being sanctioned. Mulot is being executed on 13th of November 2024. Not after a development agreement is executed, Mulot, then certain other things are to be done before a construction is Mulot.
They obtained all
yes,
permissions,
they did.
everything. You
They
sat
did.
tight over the matter.
They did, Mulot. They did.
Did nothing when the development, development was over.
Kindly,
then you came because you saw some honey in it.
No, kindly visualize, Mulot. On 14th of April 2025, I was informed of the construction. Mulot, they tried to intrude in the property in the month of December on the strength of this development agreement in the year of November 2024. I come within 5 months, Mulot.
Delay is not a major factor here, maybe, but the schedules do not tell him, sir. Primarily, you don't have a case.
Mulot, kindly.
I don't know why this injunction was granted to you.
Mulot, kindly seize this, Mulot. One is that RS.
You have to produce something to show that they're identical. Just because then any property can be taken and you can say that RS was different from the CS. How do we know that these are same? Some information slip, something. What was the conversion? Nothing. Because when you filed the suit, you knew about the schedule of their deed. You challenge that.
Yes, Mulot. 67 deed was annexed, Mulot. 67 deed was also annexed. Mulot, everything is being done after the learned judge comes to a conclusion that I have a prima facie case.
We'll modify that.
kindly visualize this.
There's discrepancy in the order.
Kindly visualize.
We'll set aside, but on a different ground.
Kindly visualize. Today, good, bad, indifferent, the dispute as
we'll set aside the entire order.
That's straight enough.
You have preferred an appeal, we'll allow the appeal in its entirety and set aside the entire order. You preferred an appeal against the order, we allow the appeal.
We set aside and permits us to go back for the order 39
for the suit.
No, to hear the order 39 1 and 2 afresh after taking because these documents I say, Mulot, subject to what eventually falls from Mulot, are essential for the purpose of adjudication of the application, Mulot. The order 41/27 application. The documents are relied upon, Mulot. He says, Mulot, the judge says merely because I could not produce my power of attorney and any document showing that I was adoptive daughter of Mr. N.S. Chaudhary, Mulot. So those have been made a part of Mulot, order 41/27. And in fact, Mulot, R.S. Chaudhary's son.
Had your opportunity, why should you permit you afresh to produce further documents?
That those facts I cannot improve, Mulot.
Injunction, this is not the identity from the identity.
No, true.
Otherwise, you had entire opportunity. Why didn't you produce the documents?
Well, it was not.
Put the documents in the suit and go ahead in the suit.
But in that even, Mulot, if they are constructing, Mulot, let them be also put to terms in terms
of security. Put to terms. They will indicate in the agreements that there is a suit.
And let that be on the edges of the court and some security, because in the event, Mulot, the suit is decided in my favor, Mulot. In the event the suit is decided in my favor, because Mulot, I have also said that this Kalu Khan, from which R.S. Chaudhary derives title, Mulot, is a fictitious person, and we have annexed documents, but those might be subject matter of trial, Mulot. But Mulot, in the event, Mulot, today, or Mulot, as and when the suit reaches its conclusion, Mulot, if
Mr. Rai, what would be your take on this? If you set because the order, there is some contradiction in the order. Mr. Kaur was right on that. If you set aside the order, because there are discrepancies we find also in the order, we don't grant anything ad interim at this stage, and we permit both parties to produce further documents if necessary, because they have produced certain documents. Order for Rule 27 is adoption, and that will inure to their benefit definitely. But even then, since something has been produced,
But our case is, I'll tell your lordship very candidly, Malad.
In the meantime, we merely construct and do whatever. But what if we set aside the order?
your lordship can set aside the order and send it back because I am aggrieved by this part. Two parts, as Mr. Kaur said, my lord. One is that the entire findings on prima facie case is against them. But the ultimately the learned judge
We
says
cannot
that
reconcile, yes, we cannot reconcile the
second
schedules
is-
not tallying but injunction
and
different.
second is, my lord, on one hand, you say that there is no prima facie case, and what you actually give is practically an injunction.
No, what practically? Full injunction given.
Yes. So therefore, I cannot sell
Therefore-
the property, my lord. Nobody, your lordship knows practically nobody will buy.
Nobody will buy. It
So
will come down.
therefore, it is an injunction.
If
That's the
we-
reason why we want to prefer an appeal.
But the price you pay for setting aside this order. No, obviously, yes, Mr. Kaur is also correct. So the price we are thinking about, there are discrepancies in the order because if the schedules don't tally, then don't give an injunction. Now, if you set aside the order, but will then the price you will pay is that we give you them opportunity, both parties opportunity to produce further documents, because this adoption, these have been brought before us. Otherwise, we have to go into these. That will not be proper because we feel the order is not correct. So they will be able to. Both of you will be able to relay documents and you can rebut also. You can take document information slips to show that these properties are actually different. They can also do the same thing. That is the price you pay. We'll revert it back to the on consent we are taking up for hearing and setting aside and remanding the injunction application to the trial court for rehearing, granting opportunity to both sides to produce documents if necessary.
Within a particular time frame. Within a particular time frame.
1 year.
What means?
That consent is coming. Consent was coming. The facial expression shows it all. He's taken a decision. Yes.
But only thing is that
Yes.
the additional documents which they have to disclose and we have
Both
to
of you will disclose to each other and
kindly fix a time limit for that. Because
this I said, I told him 1 year. I cannot tell that to you. No, the additional time limit would not help you because they'll be without injunction now.
Yes.
That's why I paid for
If
that.
that is 1 year, it will help you.
The thing is that now the date has been fixed for fixing the issues.
No, we'll fix sometime. We'll fix sometime. Definitely.
But only one correction, my lord. There was, well, Learned friend was saying that the judge has held that in 2022 there was a development agreement.
Yes.
There is a development agreement of 22 and it was produced before the court.
Oh, as well. I mean, 22 as well as 20.
We have the 24.
No, they have challenged
They have the 22.
we have a 22 also.
No. Please take your seats, all of you. We'll just thank you, everyone. In view of several arguable questions being involved, we admit the appeal to be heard on the grounds taken in the memorandum of appeal. Full stop, next para. On consent of both sides, the appeal itself is taken up for hearing in view of the conspectus of the same being short. Full stop, next para. The plaintiffs have filed a suit. The appellants have filed a suit, from which the present appeal emanates, challenging certain deeds executed by one R.S. Chaudhary in favor of the defendants / respondents, as well as the deed by which the said R.S. Chaudhary, the biological father of the appellant, purchased the property from one Bhudev Khan and one Kalu Khan. Full stop, next para. The case of the plaintiff / appellant is that she is the adoptive daughter of one N.S. Chaudhary, the brother of R.S. Chaudhary, and inherited the property from N.S. Chaudhary, who purchased the same in the year 1967. Full stop. The learned trial judge, by the impugned order, partially allowed an application, partially rejected the application of the plaintiff / appellant. Full stop. While holding that the said application is being rejected on contest, in the same breath, the learned trial judge observed that the defendants / respondents cannot claim any equitable relief in case the suit is decided in favor of the plaintiff, and that the defendants are directed to notify the prospective buyers regarding pendency of the suit, and they will be bound by the decree. Full stop, next para. Learned counsel for the appellant argues that one of the premises of the impugned order was that the property which was the subject matter of the 1967 purchase deed of N.S. Chaudhary, the appellant's predecessor, comma, does not tally with the subject matter of the purchase deeds of the defendants, comma, which is factually incorrect. Full stop. It is submitted that whereas in the purchase deed of N.S. Chaudhary, comma, the CS Khatian number was recorded, comma, in the schedule of the purchase deeds of the defendants, comma, the RS Khatian numbers were enumerated, comma, which shows an which reflects an apparent discrepancy, although the properties are in reality identical. So next para, it is further submitted that the learned trial judge observed that no document as to adoption of the plaintiff by N.S. Chaudhary was produced. The appellant has filed before this court an application under Order 41 Rule 27 of the Code of Civil Procedure, comma, internally annexing a plaint filed by a son, one of the biological sons of R.S. Chaudhary, comma, where he claims that the present plaintiff is the adopted daughter of the said R.S. Chaudhary. So it is argued that
N.S. Chaudhary.
N.S. Chaudhary, so not R.S. Chaudhary, N.S. Chaudhary. As such, comma, it is argued that if the said document is permitted to be brought on record, comma, being relevant, comma, the ground, one of the grounds on which the learned trial judge held that the plaintiff stroke appellant was not entitled to injunction would be erased. Next para, that apart, comma, the plaintiff also seeks to produce before this court a power of attorney, the absence of which had been a consideration before the learned trial judge. Learned counsel relies on a judgment reported at 2008-11 SCC 1 and submits that apparently the learned trial judge proceeded in the lines of the said judgment, where injunction was granted by restraining the defendants stroke respondents therein from transferring properties without indicating in the transfer deeds as to the pendency of the LIS. However, comma, it is contended that in the said case, comma, the Supreme Court, Honorable Supreme Court, directed security to be furnished by the defendants stroke respondents. Next para, it is contended that if third party rights are created, comma, there would be unnecessary multiplicity of proceedings and it would be difficult for the plaintiff, comma, if the plaintiff ultimately succeeds in the suit, comma, to implement the decree in against all the purchasers of the property. Thus, comma, it is submitted that since a strong prima facie case was made out and the learned trial judge herself recorded that an arguable case has been made out by the plaintiff, comma, the learned trial judge ought to have granted full-fledged injunction as prayed for. Next para, learned senior counsel appearing for the defendant stroke respondents argues that the learned trial judge correctly observed that the subject properties of the respective deeds of by which N.S. Chaudhary purchased and R.S. Chaudhary purchased and by which R.S. Chaudhary transferred the property to the present defendants are completely different. It is submitted that there is not an iota of document to indicate that both the properties are identical and, comma, as such, comma, the plaintiff has failed to prove even prima facie any right, title or interest in the property which is the subject matter of the defendant's purchase deed. Next para, learned senior counsel also points out that no substantive evidence of the adoption of the plaintiff by N.S. Chaudhary has also been brought forth before any of the before either the court below or before this court. Learned senior counsel for the respondent submits that the respondents are also contemplating a cross objection against the cross appeal against the present impugned order, comma, since the reasoning of the same is contradictory with the conclusion. It is pointed out that although the learned trial judge categorically rejected the application under Order 39 Rules 1 and 2 filed by the plaintiff appellant, comma, in the same breath, comma, the defendants were directed to notify prospective buyers regarding pendency of the suit and that they would be bound by the decree, which, comma, obviously, comma, would drastically reduce the price which can be obtained for such transfers, comma, thereby tantamounting to grant of injunction in favor of the plaintiff stroke appellant. Full stop. Upon a perusal of the impugned order, comma, we find that there are palpable contradictions in the same. Full stop. Whereas the learned trial judge observed that the plaintiff has brought forth an arguable case which cannot be settled in the absence of trial, comma, the learned trial judge categorically made several observations which run contrary to such finding. Full stop. For example, comma, the learned trial judge observed that there has been nothing has been brought on record from the end of the plaintiff to show that the property which was sold out in favor of N.S. Chaudhary in the year 1967 is actually the suit property and the subject matter of the dispute. Full stop. If the very identity of the subject property which was sold to N.S. Chaudhary and claimed by the plaintiff and that which was purchased by the defendants is in question, comma, it could not have been said by the learned trial judge that a prima facie case insofar as injunction is concerned regarding the suit property was made out. Full stop. Again, comma, even from the document which has been sought to be produced before us, comma, it cannot be conclusively said that there was an adoption of the plaintiff appellant by N.S. Chaudhary. Full stop. However, comma, we desist from commenting on the merits of the said document at this juncture, since it would be premature in view of the order which we contemplate to pass. Full stop. Next para. That apart, comma, the learned trial judge refused the injunction application, dismissed the injunction altogether, but, comma, as rightly pointed out by the respondents, comma, passed a rider to the said refusal which tantamounts to injunction, comma, by directing the defendants stroke respondents to notify prospective buyers regarding not only the pendency of the suit but that they would be bound by the decree. Full stop. Next para. The said conclusion is mutually self-contradictory. Full stop. Next para. There are several questions which have been left unanswered at this stage. Full stop. Since the appellant seeks to bring on record certain further documents, comma, we are of the opinion that for the ends of justice, comma, both parties should be permitted to bring further evidence to resolve the questions which have been left open-ended in the impugned order. Full stop. Next para. For example, comma, the plaintiff is required to prima facie show that she was the adopted daughter of N.S. Chaudhary and that the property which was the subject matter of the purchase deed of N.S. Chaudhary is identical with the suit property, as well as the properties which have been purchased by the defendants by the impugned deeds. Full stop. Next para. Similarly, comma, the defendants would be at liberty to prove the contrary on both counts. Full stop. Next para. In such view of the matter, comma, the ends of justice would be subserved in the event the impugned order is set aside, comma, being contradictory on the face of it, and the matter is remanded to the learned trial judge for a fresh consideration on merits. Full stop. Accordingly, FMAT 395 of 2025 is partially allowed on contest, comma, thereby setting aside the impugned order bearing order number 05 dated July 14, 2025, passed by the learned civil judge, senior division, second court at Asansol, district Paschim Bardhaman, in title suit number 90 of 2025, and remanding the injunction application to the trial court for a fresh adjudication upon giving adequate opportunity of further hearing to both sides. So both sides would be given opportunity by the learned trial judge to produce new documents if they deem so fit, comma, in support of their respective cases. Full stop. Such documents shall be exchanged in advance between the parties and be brought before the court by way of affidavits stroke applications affirmed by the parties. Full stop. Next para. It is expected that the entire exercise of re-adjudication of the injunction application in terms of the above observations shall be concluded as expeditiously as possible, comma, preferably within 4 months from the communication of this order to the learned trial judge. Can 1 of 2025 and can 2 of 2025 are disposed of in the light of the above observations, no orders to cost.
Could the 4 months be 2 months?
No, no, no. You will produce further documents.
We'll do that immediately. Kindly, 4 months, little too much. Complete the construction.
3 months. 3 months. 3 months.
So grateful.
Thank you. Need a problem. Wi-Fi problem?
Your Lordship, I appear on behalf of the appellant and the counsel is appearing virtually today.
Yes.
May I be permitted to appear virtually, my lord?
Yes, Mr. Chatterjee. What is the matter?
The plaintiff is the appellant before my lord.
No caveat.
No caveat, my lord.
Yes,
This is
right.
at the ad interim stage, my lord. My injunction application has been virtually being rejected. My lord, if my lord takes up the impugned order, my lord, the ground on which my lord the trial court my lord refuses, my lord, is that my lord the document which I seek to enforce, my lord, is an unregistered one. Now, my lord, if my lord sees the penultimate paragraph,
Yes.
my lord, the last page of the impugned order,
Yes.
my lord, it is the cardinal principle that within 4 months of signing the construction agreement, the construction agreement must be registered. But here, in this case, the agreement in question is not registered, and therefore the mandatory provision of registration, which is safeguard the interest of all parties involved in the transaction, cannot be claimed in the suit. So, my lord, in specific performance, my lord, kindly considers 49 of the Registration Act. There is a proviso where under Chapter 2 an unregistered document can be looked into for specifically enforcing the parties to the agreement. My lord, this part has not been looked into. And my lord, moreover, my lord, the 7 judges bench, my lord, in case of withdrawal, my lord, interplay between the Arbitration Act and the my lord, Stamp Act
Does not
my lord,
render the document void or invalid.
Yeah, absolutely, my lord. My lord, a court could have impounded it, send it for stamp, and my lord passed an ad interim order. And my lord, that becomes enforceable. My lord, this is the only reasoning, my lord, I find.
What is the injunction you ask for, Mr.
My lord,
Chatterjee?
I pray for, my lord, I have been allowed to, my lord, construct a G plus 4-story building with a right therein. My lord, I pray in the meantime not to create third-party interest, and my lord, allow me to carry on with the construction.
And allowing you to carry on with the construction is, I mean, in the nature of a, I mean,
mandatory form.
Mandatory injunction. So that
My lord, this agreement is not denied. My lord, even if I today construct, my lord, it is inured to the benefit of the defendant only. My lord, he is not allowing me to construct.
The two reliefs you said, one is permitting you to contract and the other one?
And another one, my lord, not to create third-party interest.
All right.
Yes.
But then we'll restrain both of you from creating third-party interest in the interagreement.
In the interagreement.
You can construct. You can construct.
Very good.
The present appeal arises out of an order refusing ad interim injunction prayed for by the plaintiff stroke appellant in a suit for specific performance of a development agreement.
Of a development agreement.
Of a development agreement. For sub next para, the plaintiff stroke appellant stroke developer, comma, it is argued, comma, produced the development agreement before the learned trial judge. However, comma, the learned trial judge proceeded on the premise that since the agreement was not registered within 4 months from signing, comma, the same could not be looked into for grant of injunction. Learned counsel submits that the law is well settled that in case of suits for specific performance of contract, comma, the agreement in question can be relied upon by a court of law even without it being registered. For sub next para, that apart, comma, it is argued that a document is not rendered invalid merely due to non-registration stroke deficiency in stamp affixed to it, comma, but it is a technical impediment which can very well be overcome by directing impoundment of the document if necessary. For sub next para, upon hearing learned counsel for the appellant, comma, we find substance in the contentions of the appellant. Push up apart from the uh, grounds argued by the appellant, comma, we also find that it is questionable as to whether the court can insist, no, court can refuse injunction at the ad interim stage merely on the ground that a document is uh, insufficiently stamped or unregistered, comma, before it is tendered in evidence. Push up as such, comma, even otherwise, comma, since a prima facie valid development agreement has been produced by the plaintiff, which entitles the plaintiff to make develop the property, you have started your development.
Milord, we have obtained sanction plan. We are, Milord, on the verge of study. At that time, Milord, obstructions were created.
And since all the necessary sanctions have been obtained by the plaintiff, and the balance of convenience and inconvenience lies in favor of grant of injunction as prayed for, comma, we hereby grant ad interim injunction in the no, ad interim injunction restraining the respondent and his men and agents from interfering with the construction by the plaintiff on the plaintiff stroke appellant on the suit property, and from creating any third party interest in respect of the suit property, comma, both till disposal of the present application. Uh, sorry, both till disposal of Can 1 of 2025. Full stop. Simultaneously, comma, the plaintiff appellant shall also remain restrained by an order of injunction from creating any third party interest in respect of the suit property. Full stop. The appeal is admitted on the above grounds and the grounds taken in the memorandum of appeal and shall be heard. For sub next para, the appellant shall serve copies of the injunction application and the memorandum of appeal on the respondent, indicating that the application shall be listed for hearing in the monthly list of December 2025, when an affidavit of service shall be filed by the applicant.
Much obliged.
You take these back. Mr. Chatterjee, we are giving back these judgments. You can use it when we take it up for hearing.
Riyan,
I am for the respondent number 5 and 6.
Is for the petitioner.
I am for the 4.
None appears for the
My lord,
petitioner.
I for the petitioner.
Move the matter. You are not responding. You are asking who is for the petitioner.
But due to my affidavit of service.
Yes, what is the matter?
But the matter arises out of
You
a.
have served on all.
Yes.
Yes, arises out of.
My lord, it is a matter, my lord, where I am not party, my lord, for what I have filed an application for CAN, my lord, because I am affected by that order.
How are you affected?
My lord, straight away comes to the, my lord, page 65. My lord, this is the genealogy table.
Yes.
My lord, this Khetronath Bhattacharya was the absolute owner.
Hmm.
My lord, in respect of the plot number 919 and 922.
All right.
My lord, this Khetronath Bhattacharya died, leaving behind his wife, 4 sons and 2 daughters. My lord,
Right.
this wife and 1 daughter, my lord, this Geeta,
Huh.
my lord, they have transferred the property in favor of his 4 sons by a registered deed of conveyance, my lord, in the year 1958.
Very well.
My lord, thereafter, these 4 sons, my lord, ostensibly sell the entire property.
Lotika was still alive when the sale took place.
Lordship.
They ostensibly
sell the entire property in favor of the respondent number 5 and 6,
who are they?
ignoring the share
Third
of
parties.
Lotika.
Acha. So they sell the entire property.
Entire property, ignoring the share of Lotika.
Huh.
My lord, thereafter, the Lotika died in the year 2000.
You are the heirs of Lotika.
The heirs of the Lotika is Deepak Bhattacharya and Triguna.
You are?
My lord, I am the purchaser, my lord, who purchased the share of Lotika by virtue of a conveyance in the year 2016
You purchased from
Deepak.
whom? From Deepak.
From Deepak. 2016. Not 1/7 share by the conveyance. But thereafter, my lord, I made an application before the BL and LRO for restoration of my 1/7 share.
Restoration means?
Not for
the BLRO do that.
Not 1/7 share in the Khotian.
You asked for recording of that.
Recording of that.
It was already recorded in the name of the 4 sons.
For in the name of the R5 and 6
purchasers of the 4 sons.
purchasers. Lord, BLRO rejected that application that I moved before the
This
ADM
is a
LRO.
civil dispute. How can the BLRO decide this?
Lord, this is an apparently an admitted fact. Lord, there is no dispute that I am.
How did the BLRO deal with it?
Lord, BLRO rejected that. Lord, against that we preferred an appeal before the ADM LRO. Lord, ADM LRO passes an order in our favor for restoration of 1/7 share. Lord, thereafter, Lord, there is a difficulty. Lord, at the time of passing of that order, Lord, this Deepak Bhattacharya, Lord, died before passing of the order. For that reason, Lord, the order became a nullity in the eye of law.
It was passed in the name of Deepak.
Deepak, in favor of Deepak.
No, Deepak sought for that rectification in his name.
Deepak sought for the rectification.
Not you.
Not me.
But
Lord,
you had that was before 2016.
Lord, that was before 2016.
Very well. Then
Lord, thereafter I came into the picture.
Then what happened?
In the year 2016.
Nullity, they moved the tribunal against that.
They moved the tribunal.
4 and 5.
4 and 5. When they moved before the tribunal, they served a summon in favor of the Deepak. And from them they came to know that it was died.
So tribunal set aside on the ground of nullity.
On the ground of nullity. Lord, my contention is that
the appeal revives.
Lord, the appeal revives. Lord, the tribunal said that let the
Appeal
matter
revives in the say. What did the tribunal say?
Lord, kindly takes the order.
The heir should be substituted.
Not like that. Lord, it remanded the matter and with consideration for substitution of the year. Lord, after setting aside the abatement.
Now you can go there and file it in the nature of order 20 rule 10.
Lord, what happens is that Lord, by this order, Lord, I am the admitted owner in respect of the property.
Admitted?
Lord, whatever with the facts and circumstances, Lord, I am the owner of 1/7 share. Lord, I made an application for the BLLRO for making mutation in my name. Lord, they contested.
Did you make that application again? So all these things were going on.
Lord, when the order of the the ADM LRO subsists, Lord, I made an application. Lord, based upon this, Lord, the BLRO made an order in my favor. Lord, I became my name has been recorded in the Khotian.
As 1/7 owner.
1/7 owner.
So now what?
Lord, by virtue of this order, Lord, I became affected.
How are you affected?
My lord, because
they have not asked for rectification.
My lord, because the principle of restitution will apply.
Deepak had asked for restitution, rectification.
Rectification. My lord, I am the purchaser from Deepak.
Yes.
My lord, there are my lord, the deeds. Not from
So therefore, the appeal now the rejection order remains. Deepak's order was rejected.
Lordship.
Now it goes back to that stage because the appeal is pending now.
Lordship.
After the one.
Lordship. My lord, these two, my lord, from where they are claiming
So subject
right.
to what they say, we can permit you to be implemented before the appellate authority and carry on with the appeal.
Lordship.
Let us hear Mr. Mitra and Ms. Yes. What do you say? We'll do that.
So far as we are concerned, my lord, my father, it appears now that my Deepak died during pendency of the appeal.
Filing the appeal.
No.
And when the notice was served, my lord, Deepak already died.
It was an analysis. The appeal was no. Then who filed the appeal? How could he file the appeal?
My lord,
Advocate always appeared and
my lord, difficulty
before
is, my
before
lord,
filing of the appeal, if he died, how could the appeal be filed?
no, no.
yes, my lord,
Appeal
the notice with
when he was pending at that time, my
That
lord,
time he died.
his power of attorney holder, they were proceeding.
this is the
Power of attorney ceased with his death. No, we understand. We understand. We keep it to you. Yes.
My
He
lord,
might have died before the appeal even. Power of attorney carried on with the appeal, and it was subsequently might have been discovered.
so far as that is concerned,
What is the
my
date of filing of the appeal? What is the year of the appeal?
the year of appeal is of my lord 17.
Date of
not 17,
date of
my
date
lord.
of death 18th November 2022.
2020?
22.
Then during pendency.
And the appeal finally disposed of on 3rd May
Great
2020.
one. Well, let me hear. Deepak filed mutation application before the
When did Deepak die, according to you?
2022.
18th November
When
2020.
was the appeal filed?
Appeal was remanded back, and thereafter notice was served on me on 24th of January 2023. This is the first notice of the appeal after remand. In 2000,
After, there was a previous remand also.
Previous remand.
Appellate authority after remand passed the final order on 3rd May 2020.
So therefore, in the interim, the appeal had already been filed. It was remanded during that stage. Probably
Yes,
appeal was there.
yes.
So we'll permit him to be implemented there and conduct the appeal. It has in any event been remanded. Let us see the remand order here. So what is your ground of challenge to the appeal?
Not the ground
to the order.
Not the ground of challenge is that, my lord, the order.
Rightly remanded. Where is the remand order? 10th of September is the impugned order.
10th of September is the order of the tribunal. My lord, 10th of September, my lord, the tribunal may not pass the reasoned order. My lord, what happens is that, my lord, the respondent number 4, the respondent number 3, my lord, that is
respondent number 4.
my lord, respondent number 4. My lord, respondent number 4, I see from the order sheets, my lord, they heavily relied on judgment of the Supreme Court.
We are not entering into the
My lord,
merits.
they stated that, my lord, when the legal heirs, my lord, came into the picture, my lord, they either can sought for, not for.
Is there any application for substitution? The legal heirs, there.
Yes. That is
Legal heirs of Deepak have already applied.
Yes, is allowed by the tribunal.
Sorry. So this Deebakar has been allowed, and
Allowed.
Triguna is also there.
No.
No, Triguna died.
Only Deebakar has been allowed.
Yes.
So we'll permit him to apply for addition of party in the appeal. We'll permit him to do that.
May I
He
pray
claims a title. He has the right.
May I pray one thing, my lord? Kindly have to, on behalf of Deepak, I represented before the tribunal. But the 2016's deed, this is not in my knowledge actually. I have talked with Deebakar Bhattacharya.
No, we are permitting him to apply before the appellate authority for getting implemented.
Instead of appellate authority, your lordships
It
kindly
has been remanded to the appeal.
Your lordships kindly have to see this judgment. Instead of tribunal will have to decide this, my lord. Time saving. Your lordships kindly have to see this judgment is totally ignored by the tribunal. This is 3 judges bench judgment. If a judgment has been passed against a dead person,
it was a nullity.
2 options were bestowed upon the heirs of the deceased, that either you will have to challenge this on merits or it is a nullity. 2 options has been given by the Honorable Supreme Court 3 judges bench.
Can there be an option? It's a nullity. In the name of a dead person is a nullity.
My lord, I have cited before losses, your losses can please that entire discussion is upon the heirs.
We don't find any irregularity judgment in the judgment of the tribunal. It has been held to be a nullity It has been remanded, and the substitution application, the substitution application was filed before the tribunal.
Yes, that has been allowed.
That has been allowed, and it has been remanded rightly, absolutely right to judgment. But we'll carve that niche for him to apply there. If his application is allowed, he'll have to satisfy the appellate authority that he has a title, some semblance of a title, then he'll be permitted to.
One thing I would like to add, my lord, there is a title suit pending in the Barashat court, my lord, where the petitioner was a party, and in the body of the suit, my lord, it is all the written that one matter is pending before the tribunal. They could have joined in the tribunal, my lord, if they have purchased the share in 2016 at all. Because if they purchased 2016 at all,
They didn't, because they were merely enjoying that recording in their name. 1/7.
no, my lord, because they have.
They have a recording in their name now, even.
Still now, that even not challenged.
That has not been challenged.
My lord, at that point of time, tribunal is proceeding with the appeal. And in 2024, rivalry contention came. One from Dibakar Bhattacharya, who is claiming share of Deepak, and one from petitioner company, who is also claiming share of Deepak.
No, but even if they knew about the pendency of the tribunal matter, tribunal adding them in the tribunal would not serve any effective purpose, because in any event it has to go down.
Knowledge about the suit, in the suit, with the copy of the suit, someone was served in 2024.
Suppose if they don't implicate themselves in it before the tribunal, that does not take away any right or create any right,
No.
because tribunal only had to say it's a nullity.
Yes, ma'am. Yes,
So the substance has to be decided by the appellate authority ultimately.
yes, ma'am.
So we'll give them that liberty, they can apply. The conspectus of the affidavit of service filed to be kept on record. First of the conspectus of the present writ petition is short. First of next para, the petitioner claims to have purchased 1/7 share from one Deepak Bhattacharya in respect of the plots in question in the year 2016. First of next para, the brief background is that one Kshetronath Bhattacharya was the original owner of the property.
My lord, he was not the sole owner, my lord. There was he was moiety share. One Bhupendra was also
50% share.
50% was one of the co-owners of the plots in question. Pusab, he had two daughters. He left behind two daughters. He left behind his wife, 4 sons and 2 daughters.
That 2 daughters, my lord, is under dispute, my lord. I am disputing that he Kshetronath
Very well.
behind.
Kshetramohan
This
থেকে
is my
কেটে দাও। কেটে দাও।
Their deed also shown.
The present petitioner purchased, যেটা বললাম ওই দীপকের সেন্টেন্সে রেখে দাও। তাই ক্ষেত্রমোহন original owner ওই সেন্টেন্সে কেটে দাও। তার বদলে লেখো, it is alleged by the petitioner that one Kshetramohan Bhattacharya was the original owner of the property. He left, full stop, he left behind his wife, 2 daughters and 4 sons. Full stop, next para. Subsequently, it is alleged by the petitioner, the 4 daughters, the wife and one of the daughters, Gita, transferred their shares in favor of the 4 sons. Full stop, next para. The 4 sons, the petitioner alleges, by usurping the share of the remaining daughter Lutika, sold out the property in favor of the respondent numbers 4 and 5.
5 and 6.
Respondent numbers 5 and 6. So next para. It is further contended that the petitioner purchased the property from Deepak Bhattacharya, one of the sons of Lutika. Full stop. The petitioner claims to have applied for recording his name on the strength of the 1/7 share purchased by him, and the said recording was duly done in the records of rights. Full stop. However, in the interregnum, the application filed by Deepak Bhattacharya, the vendor of the petitioner, during his lifetime, for mutation stroke recording in his name was refused, against which an appeal was preferred by Deepak. Full stop. The appellate authority allowed the appeal, directing the recording of the name of Deepak. Full stop. However, when a challenge was preferred against the said appellate order before the Land Reforms and Tenancy Tribunal, it was detected that Deepak Bhattacharya had died on November 18, 2022, comma, that is during the pendency of the appeal. Full stop. Next para, you are for 6.
5 and 6.
And Mr. Mithu, you are for
4.
4. Learned counsel,
I want to refer one page, my lord, page 104.
for what?
This is the mutation application and order of the petitioner, my lord. The mutation application was allowed even before filing their application. Hello, kindly see page 1.
You're not going into the detail. Yes. Next para. Learned counsel appearing for the respondent number 5 submits that the matter was previously remanded by the tribunal as well, and in the interregnum, comma, the said Deepak had died. For sub next para, it is further submitted by learned counsel for the respondent number 4 that you don't have any stand as such neutral.
No, for the present we have no stand.
আচ্ছা তাহলে এটা ছেড়ে দাও ফার্দার সাবমিট এটা কেটে দাও Upon hearing learned counsel for the parties, comma, it transpires that it is an admitted position that Deepak Bhattacharya, comma, the appellant before the appellate authority died on November 18, 2022, comma, that is before the passing of the order by the appellate authority, which was challenged before the tribunal. Thus, comma, the learned tribunal, comma, while passing the impugned order, comma, was justified in setting aside the order and remanding the matter to the appellate authority by allowing the substitution applications filed by the heir of Deepak Bhattacharya, namely one Dibakar Bhattacharya, comma, on the premise that the appellate authority apostrophes order was a nullity in view of the demise of Deepak prior to the same. Next para, insofar as the right claimed by the petitioner is concerned, comma, we find that there is substance in the contention of the petitioner that the petitioner's right, comma, if any, would be adversely affected in the event the outcome of the appeal turns negative. Next para, in any event, comma, since the petitioner has an interest in the present lease, comma, we allow can 1 of 2025, comma, thereby permitting the present appeal to be filed at the behest of the present writ petition to be filed at the behest of the petitioner. In tune with the above observations, comma, the present petitioner ought to be given an opportunity to approach the appellate authority to implead himself as a party thereto on the strength of the purported deed executed in his favor by Deepak, comma, the son of late Lotika. Next.
Husband. No. Deepak.
Son.
No.
Trigona was husband. Son of late Lotika. Next para. Accordingly, accordingly, WPLRT 181 of 2025 is disposed of without interfering with the impugned order, comma, granting liberty to the present petitioner to make an appropriate application before the appellate authority for being impleaded in the appeal. What was the number of the appeal?
Appeal case number
500 of 2017.
Appeal case number, yes, appeal case in appeal case number 500 of 2017. If such an application is made, comma, the appellate authority shall consider the same in accordance with law, dispose of the same in accordance with law after giving adequate opportunity to all parties on the said application, comma, without being influenced on merits by any of the observations made above. No rest to cause urgency.
Before the tribunal, application for substitution allowed.
That has been allowed. That remains.
And again, the tribunal directed you will have to file an application before the appellate authority for substitution.
By whom? The son?
Tribunal, by impugned order.
Filed by the son to be filed. Whatever that is there. He will also file an application. Son has an option to file or not to file.
I'm had the petition track report, my lord, in respect of private respondent has not delivered his source mail. So you will keep it tomorrow, my lord.
Tomorrow, by tomorrow it will be delivered. When did you send?
Friday that was sent.
We'll keep it next week then. Tomorrow we don't know whether it will come. Lord Counsel for the petitioner submits that the private respondent has not yet been served. So accordingly, let the matter stand adjourned till November 17, 2025.
Your Lordship, I am for the respondent.
Right, yes.
Your Lordship, it is the matter yesterday taken up regarding that COVID period coverage.
Yes, yes. Why did you adjourn it?
Because I am unable to assist your lordship properly.
Just remind us, Mr. Rai.
Yes, the judgment.
Oh, that. We got angry with you because you are not sure of 21 or 22. It was 22.
22.
Remind us the facts. Short.
I am the testator. So far, the appellant before your lordship is the executor who applied for the probate of the will last will of his son. Probate granted. Against that, my learned friend filed an application for recalling of the probate on just ground. That was allowed. Against that.
On what ground?
Just ground, but that proper service was not effected.
Citation.
Where, yes, citation. But that there are issues because on the basis of which this honorable court directed to produce evidence to prove that they are aware about your whereabouts at the time of filing of this probate.
No, they filed a revocation application.
Yes, revocation.
Obtained a probate, they filed a
Revocation application.
Or you related to the testator, both of you?
I am the father and she is the wife.
No.
Wife or mother?
Wife.
Actually, the son died leaving behind wife and one minor daughter.
You are the wife and minor daughter?
Yes. I am representing.
That is what he's saying. That is what
the
he's
wife of the son, as if he represents the wife of the testator, he is saying.
No.
That was the confusion, he cleared it, yes.
And because that this appeal has been filed. Now, if your lordship takes up the order dated 18th
No,
March.
revocation was allowed.
Allowed. Challenging that matter, I am before your lordship.
So what is the ground in the appeal?
Yes, because your lordship
was not given on the wife. Right.
It was published. It was not only that, general citation, apart from that, a special citation was also issued. They came before this honorable court challenging an direction passed by the learned court below while asking them to adduce evidence that you are saying categorical statement is that they are not known about your whereabouts at the time of filing of their petition. Because last non-residence, the notice was issued. After that, in spite of that order, nothing was produced before the court below.
We will go into that. But now, present.
Now, my lord, can you consider the order?
5 or what?
Beg your pardon?
Section 5. This
No, my lord. For injunction not to transfer at least. Now that it has been revoked.
No, why did you go into the question of that?
Yes, that your lordship can takes up the order dated last order.
1st March 2022.
Wait a minute, order this is a default with এইটা না দিদি
আচ্ছা আগের দিন এটা হলো তারপরে সাজিয়ে দেননি
one thing
আগের দিন তো বললাম যে এটা সাজিয়ে দিতে সব কটা বলি তার আগের দিন তো হলো তখন পাচ্ছিলাম না তারপরে তো সাজিয়ে দেননি yes 1st March
2022 order.
Got it, yes.
Yes, my lord will find the last portion of the order where your lordship will find the appellant is directed to remove the defect as pointed out by the additional stamp report on 9 June 2020. Within a period of 2 weeks from date, failing which the appeal stand dismissed without any further reference of this court. So if your lordship
Two of the defects of 9 June was you had rectified.
Yes, rectified, my lord. Your lordship find the back side of the memo of appeal. It was recorded that the defects were removed on 22nd March 2022.
Oh, which was you say within that COVID period.
Yes. Now, my lord, this is the
COVID restriction ended when?
It was 90 days from 1st March 2022.
And removed on 22nd
March 2022. It was removed. My lord will find the additional stamp reporter's report. I am drawing the last portion of the order.
Why pages of different colors?
Oh, so sorry, my lord. It's fine. This is
মাঝখানে একটু পাপাতা ফিরে গেছিল তুমি চলো অলওয়েজ
আমি দিয়ে দিচ্ছি এক্ষুনি দিয়ে দিচ্ছি Your lordship will find 3. I. Page 4, internal page 4, my lord, got it? In event the actual balance period is limited remaining with effect from once, it is greater than 90 days, the longer period shall apply. So in any event, my lord, it was done within the period which is there.
Your lordship, kindly come to the first at page 4, clause 3.
Yes.
It is written in cases where limitation would have expired during the period between 15th March 2020 till 28th February 2022. Within this period, whatever limitation has expired, that be covered by this order, not the direction passed on 1st March. Because COVID period was 2020 and 2021. 2022 was never adjudged as a COVID period. And these orders were passed to safeguard in cases of new applications where limitation is expiring within 2020 and 2021. Not that the direction which has been passed in their presence, which has been passed in their presence, I'm sorry, your lordship, on 1st March 2022. It was a specific direction. This, this clause is not applicable in this stand case, your lordship.
Yes.
He's right.
Now, my lord, can turn to the page,
Not for fresh orders.
page 3. First. The order dated such and such is restored in continuation with the subsequent orders dated such and such. It is directed the period from 15 March 2020 till 28 February 2022 shall stand excluded for the purpose of limitation as being prescribed under any general or special laws, so all judicial or quasi-judicial proceedings.
So everything is covered till 28 March, 28 February 2020.
Consequently, the balance period of limitation remaining as on 3rd October 2021, if any, shall become available with effect on 1st March 2022. In cases limitation would be expired during the period of 2020, 15th March.
No, the precondition, Mr. Rai, is that it had to expire on 28th of February.
Right. Yes.
Period from this is for that period up to 28th of February 2020 because COVID was not there on 1st of March 2020.
Yes, 21st of March, the subject to correction is 2020 onwards.
Your default was the direction was
on 1st March.
This direction was given by the on 1st of March
2022.
So this was not a case where the limitation expired before 28th of February 2020. This is a subsequent. The first order is subsequent. So this was the order itself was direction itself was passed after the COVID period.
No, COVID period was subsequent.
COVID period ended on 28th of February 2022. That is deemed by this order.
Yes.
And for that period, that would be added. The period when if
90 days.
If it expired in the first place, it had to expire. The limitation had to expire. For that period, that limitation was extended. But then by this logic, your logic, everything will be covered by this. Whatever happens even after. This is only for the period when the last date of limitation fell due before 28th of February 2022. He is right on that.
The actual balance period is
because if your logic is borrowed, then even on this order was passed on 1st of March 2022. So this is not covered by these orders. Not covered by these orders. Then even today, if we pass an order, that 3 months period would be added.
No.
Yes, because this is applicable to it is directed the period from 15 March 2020
with effect from
till 28 February 2022 shall stand excluded.
Yes.
So there is no question of that period standing excluded because your limitation, the direction itself was on 1st March 2022. After this.
So only for that purpose. Then,
so therefore it
is because filing of an application ballot for recalling on Lojima order.
But then it will be very difficult for you because this is the second time you are defaulting.
No, it was that period ballot. It is not that it has already been complied with in that on 22nd March 2022. It was removed. It was directed to be removed by 14 days.
Pointed out by learned. No, Mr. Rai, you have to file an application.
Yes.
It is pointed out by learned counsel for the respondent at the outset that by an order dated March 1, 2022, a coordinate bench had recalled an earlier order dated March 8, 2021, by which the appeal was dismissed for non-compliance of the court's direction, on the basis of an undertaking that the appellant shall be present on all future dates of hearing. Next para. It was further directed that the appellant shall remove the defects as pointed out by the additional stamp reporter in his report dated June 9, 2020, within a period of 2 weeks from that date, that is by March 15, 2022, failing which the appeal would stand dismissed double inverted without further reference to this court, double inverted close, full stop. Next para, it is pointed out that the appellant did not make good the defects within the said period as stipulated in the order dated March 1, 2022, which would in fact be evident from a report of the Registrar Administration within bracket L and OM dated April 18, 2022. Which the next para, learned counsel for the petitioner submits that was his argument yesterday. Learned counsel for the petitioner submits that the order dated April 18, 2022 was on a different count, that is non-filing of Tolobana of ₹4 and written up notice forms, which was not a part of the report of the additional stamp reporter dated June 9, 2020. Insofar as the June 9, 2020 defects are concerned, those were removed on March 22, 2022. Next para, learned counsel for the appellant stroke petitioner relies on an order passed by the Honorable Supreme Court during the granting COVID relaxations, where it was observed inter alia that the period from March 15, 2020 till February 28, 2022 shall stand excluded for the purposes of limitation as may be prescribed under any general or special laws in respect of all judicial or quasi-judicial proceedings. Also, it was observed that in cases where the limitation would have expired during the period between March 15, 2020 till February 28, 2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from March 1, 2022. Next para. In the event the actual balance period of limitation remaining with effect from March 1, 2022 was greater than 90 days, the longer period was to apply. In reply, learned counsel for the respondent submits that the said order is not applicable in the present case, since the limitation for depositing the rectifying the defects did not expire between March 15, 2020 and February 28, 2022, but arose in terms of an order dated March 1, 2022 itself. Next para. On a perusal of the report of the Registrar Administration within bracket L and OM dated April 18, 2022, we find that the same indicates that Tolobana of ₹4 and written up notice forms were not deposited by the appellant within time for which further time was granted. However, the said defect and the said flaw on the part of the appellant cannot be said to be a defect within covered by the report of the additional register dated June 9, 2020, which was the premise of the order dated March 1, 2022 passed by the coordinate bench. In terms of the coordinate bench direction dated March 1, 2022, however, the defects were to be mandatorily removed. The defects as pointed out by the additional stamp reporter on June 9, 2020 were to be mandatorily removed within 2 weeks from that date, expiring on March 15, 2022, with a rider that in default, the appeal would stand dismissed without any further reference to the court. Full stop. Next para. Admittedly, comma, in the present case, comma, the defects were cured on March 22, 2022, comma, that is beyond the period as stipulated in the order dated March 1, 2022. Full stop. As such, comma, there is no scope or power of the court to condone the delay or extend the time, comma, since the said dismissal was automatic and without reference to the court. Full stop. Insofar as the reliance of the appellant on the Supreme Court extension, pandemic extensions of time is concerned, comma, the same, comma, as rightly argued by learned counsel for the respondent is misplaced. Full stop. The said relaxations were applicable only in cases where the limitation period expired on or before February 28, 2022. Whereas in the present case, comma, the direction of the division bench of the coordinate bench was itself passed on March 1, 2022, and as such, the limitation for putting in the deposits ended on March 15, 2022, that is beyond February 28, 2022, comma, thus taking the present case outside the ambit of the COVID relaxations granted by the Honorable Supreme Court. Hence, comma, the appeal stands automatically abated. Appeal stands automatically dismissed for non-compliance of the court's order dated March 1, 2022, in view of the appellants having cured the defects only on March 22, 2022, that is beyond the stipulated period. Full stop. Hence, comma, all orders passed thereafter in connection with the appeal, comma, if any, are a nullity. Full stop. In view of the above, comma, the present applications cannot be entertained at all. Full stop. However, comma, on the prayer of the appellant, comma, leave is granted to the appellant to file an appropriate application for restoration of the appeal if the appellant is otherwise so entitled in law. Full stop. If such an application is filed, comma, a copy of the same shall be served on the learned advocate for the respondent in advance. Full stop. Liberty to mention the application as and when filed. Thank you. Very good arguments. Yes. What is your full name?
Abhijit Chakraborty.
Yes. Thank you, sir.
15 and 16, I was humbly praying, this is a custody matter, this may be taken up in camera.
Yes, a live streaming to off করে দিতে হবে। What is the matter, Mr. Woods?
This is out of time, my lord.
Section 5, serve and come back.
My lord,
This arises out of an injunction order?
no, my lord. Eviction suit.
Or regular first appeal?
Yes, yes.
So serve copies of both the applications and come. The appellant shall serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondents, indicating that the application shall be listed for hearing next on November 24th, 2025, when an affidavit of service to that appeal shall be filed by the applicant. Come back on 24th, we'll dispose of the section 5, take up this. 8 minutes.
Lordship, I am appearing for the appellant.
Yes.
My lord, there is 3 days delay. Section 5 has been filed. I must.
3 days delay means?
My lord, 3 days delay is there.
3 days?
3 days.
I thought we heard.
No. This is, my lord, against the.
No, there is no section 5.
Yes, I have filed section 5.
Even if say 3 days you have to serve a copy.
Yes, I will serve mine. I will serve mine.
Serve and come back with directing. Here also like the previous case.
I have instructions to
You are
appear.
appearing?
I have instructions to appear on behalf of
Very
the
good.
respondents.
You have saved the postal costs.
Yes. Then I will serve
Very
in
well.
my lord.
Very well.
Copy ache naki?
The petitioner shall serve copies of.
Here and now I am serving my lord. I have an extra copy, my lord.
On the prayer of learned counsel having instruction to appear for the respondent, the appellant is directed to serve copies of both the applications and the memorandum of appeal on the learned advocate for the respondent during the course of the day. Full stop, the matter shall be taken up tomorrow under the same heading. Come.
My lord, tomorrow, can it be day after tomorrow only?
Can it be Monday, my lord? Or on Monday, my lord.
As well as Monday.
Monday.
Great. Next date, tomorrow na kore on November 17, 2020.
Great.
November 17. Great.
Monday. Give your appearances.
Yes. May please your lordship, I am appearing for the.
Yes. What is the matter,
appellant.
please?
And this is affidavit of service.
Right.
Affidavit
They have been
of
served
service
proper
is
service.
effective.
Right.
Is complete.
What is the matter?
Matter, my lord, this is an application for stay. Can number 2. Kindly take up can number 2. My lord, this is an application. Plaintiff appellant is before your lordships. Now, the plaintiff filed a suit for declaration of title and permanent injunction alternative prayer with partition. The plaintiff's father, my lord, the original plaintiff Nimai Mohanto, purchased 2 decimals of land in plot number 71, 2 decimals of land in plot number 72, and 2 decimals of land in plot number 71 of Mauja Simla from the, my lord, from one Poriwala Dasi. But after purchase, my lord, he has constructed his residential houses and he has been residing in that houses, my lords, with his family members. Now the
There are
defendants, my lord,
2 appellants, 4 plaintiffs.
4 plaintiffs.
Seven
My lord,
plaintiffs.
original plaintiff was one Nimai Mohanto. During the pendency of the suit, my lord, that Nimai Mohanto died, and my lord, thereafter
Yes.
substitution application was made by the plaintiff.
So what happened?
And
What
they
are you
have
challenging the appeal?
Now kindly come to the, my lord.
No,
order
tell us what
passed
have
by
you
the
challenged in the
learned-
appeal? What have you challenged in the appeal?
Well,
Suit has been
because of,
dismissed.
my lord, the suit was dismissed by the, my lord, learned judge. Kindly come to the, my lord, judgment passed by the learned
Just
judge.
tell us before going into the judgment, what is the why it was dismissed? You failed to prove your title.
My lord, kindly see the judgment. Only 2 pages judgment.
Very.
That is at page 36. That is at page 36.
This is the entire judgment.
Yes, my lord. This is entire judgment, 36 and 37. 2 pages judgment. And my lord, kindly see what is the, my lord, observation decision with reason. My lord, exhibit 1, that is the certified. Kindly see, my lord, page 36.
Yes.
The plaintiffs produced the exhibit 1, the certified copy of the deed number 3042 for the year 1970.
This is your purchase deed, father's purchase.
Yes, my lord. And my lord, exhibit 2, LR Khotian, exhibit 3, original deed number 3042, 1970, exhibit 4, 1579, 30, 1980. Well, this 1980 deed, the plaintiff's original plaintiff Nimai Mohanto purchased by this deed. Well, fact is that originally the suit plot was belonged to one Gosto Bihari Gorai. Well, he sold the suit land to one Kaminibala Dasi in the year 1951. My lord, after 1951, that Kaminibala Dasi died before the revisional settlement came into operation. Well, that Kamini Bala Dasi was issueless. She had no issue and she died living intestate with the nephew of Chinivas Nayak. Chinivas Nayak was her husband. But that nephew's name Premchand Nayak. And Premchand Nayak, my lord, inherited that property. And Premchand Nayak, my lord, died while leaving his only daughter, Goribala Dasi. Goribala Dasi. Goribala Dasi dated যেটা বিক্রি করে প্রথম জামিনী কামিনী বলার 1951. মানে these are the exhibits. এইটারে বাবা আরেকটা দেখ well here it is clear statement that the purchaser is Kamini Bala Dasi alias Jamini Bala Dasi, wife of Malar Chinivas Naik Bhuya, and the Malar seller goes to Bihari Gorai. Well, after selling of that property, Kamini Bala Dasi became the owner of the property against plot number 70, 71, 72. Well, then kindly come to the observation.
Yes, we have asked for stay. What have we asked for? Dismissal.
Yes, stay.
Dismissal of suit. What will you do with a stay?
My lord, because of my lord.
Suit has been dismissed. What will you stay? Stay means the suit will be revived. Injunction we could have understood. You have not asked for injunction.
My lord, let it be treated as injunction.
Have you made the necessary averments? You have not made even the prayers. We could treat, but if you made the prayers.
My lord, let my lord be given me.
You have not even alleged that they're trying to
injunction application.
File an injunction, I will give you liberty. Immediately will give you liberty.
My lord, kindly, my lord, take up only can number 1, my lord, where my lord, I have my lord prayed for repairing of the house.
Serve copy of this application on the other side. Oh, you have served.
All the copies have been served upon the.
Was there a direction by the court, or do you served of your own?
No, my lord, there was no direction.
Without direction, service is meaningless. You have to serve by direction because you know the previously we are used to issue a rule. Only then you could serve. That has been replaced by this service. By yourself, if you serve, if they appear, it's all right. But if they don't appear, you have to serve.
Grateful to my lord.
Would you like to withdraw this stay, or will dismiss this stay and grant you leave to file?
Grant me leave to prefer
Very well. Can 2 of 20, the present appeal arises against an order of, against a judgment and decree of dismissal of a partition suit filed by the plaintiff/appellants. Full stop. Can 2 of 2025 is an application for stay of operation of the decree. Full stop. However, since the suit has been dismissed, there is no scope of grant of stay. Full stop. Accordingly, can 2 of 2025 is dismissed with liberty to the appellants to file an appropriate application for injunction if the appellants so deem fit and proper. Full stop. Next para. Can 1 of 2025 is an application for
interim order for allowing the plaintiffs, my lord, to repair their
permission
dilapidated house.
Repair the residential mud houses of the plaintiffs/appellants at the suit property. Full stop. The appellant shall serve a copy of this application on the respondent, indicating that the application shall be listed. We'll fix a short date.
Grateful to.
Today we are on 11. Can you do it by 1 week? I don't think it will be served.
1 week, my lord, it may not be served, my lord. Kindly
2 weeks we are giving.
2 weeks.
Listed on November 24, 2025, when an affidavit of service shall be filed by the appellant.
Grateful.
Thank you. You can take back this original. You handed over this. Take back the original. And in the meantime, you file an injunction. If you mention that, we'll take that on the list.
Yes,
Also.
my lord, grateful.
If you file the injunction and mention it, just remind us that this other application is due to appear on 24, so that we can list it along with that. And in the slip you write with such and such.
Grateful.
I am for the appellant, my lord.
Yes, Mr.
This is a suit
I am
for the
appearing for my lord. Respondent, plaintiff, respondent number, my lord, 1 and 3.
This is a suit for
Why? What about
partition.
2? 2 is also plaintiff.
Yes.
Why don't you appear for him also?
They have appeal.
Kalodrama, my lord, signed by 1 and 3, my lord.
Convince them for the
This is a
other.
suit
Because
for
otherwise,
party-
this will unnecessarily be delayed. We have to serve. Anyway, what is the
This is a suit for partition against the preliminary degree. I have come before your lordship
And can 2 is the application for stay of operation of the judgment, and can 1 is the additional evidence.
Usual orders in both. Serve on the others, partition suit.
Partition suit, madam, all are not appearing.
Okay.
I am the only contesting defendant and they are the plaintiff. 17%
If
is
you
there.
appeared for 2, we could.
1 and 3.
If you appeared for 2, we could dispose of this application itself so that it was expedited. But now you'll have to suffer a stay. Fine. Anyway. In view of appearance, comma, service of copy of the application on the plaintiff stroke respondent numbers 1 and 3 is dispensed with. Yes, full stop, next para. Since the pro forma respondents, comma, as per the submission of, since the other respondents, that is respondent numbers 4 to 17, comma, as per submission of learned counsel for the appellants, comma, did not contest in the court below, comma, service on the said respondents is dispensed with for the present. Full stop. The appellant shall serve a copy of the application on the respondent number 2, indicating that the applications shall be indicating that can 2 of 2025 shall be listed next on November 24, 2025, when an affidavit of service shall be filed by the appellant. Push up there. In the meantime, comma, the trial court shall proceed with the final degree proceedings. Push up, however, comma, no final degree shall be drawn up during pendency of the application, during pendency of can 2 of 2025 without leave of the court. Push up, next para. Can 1 of 2025 is an application in the nature of Order 41, Rule 27 of the Code of Civil Procedure. Push up, accordingly, let the said application be listed for hearing along with the appeal when the latter is ready for hearing. Push up, affidavits, if any, in respect of can 1 of 2025 shall be exchanged in the meantime. Push up, the application can 2 will appear on 24th November.
Yes.
But in the meantime, we are directing you to put in the postal costs and all the other things. The appellant shall put in postal costs, written up notice forms, and requisites for service of notice of the appeal on the respondent numbers 2, and that you have to serve on all. Nothing doing. Respondent numbers 2 and respondent numbers 4 to 17, comma, within a fortnight from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a fortnight. Full stop. The trial court shall be entitled to retain a skeleton records for proceeding with the final degree proceedings. Full stop. Next para. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. But this application appears on 24th.
Yes.
If you can take instruction in the meantime to appear for 2, then this exercise will be shortened.
My lord, I am for the respondent.
I appear for the appellant.
Yes.
My lord, my only humble prayer is let this matter be adjourned for a fortnight. We have just received the brief yesterday.
Our only answer is no. Only humble answer is no. You have to move the matter right. The appeal arises. Why fortnight? You are not prepared.
No, my lord.
When did you receive the brief?
We have just received the brief
Just
yesterday.
means day before yesterday.
Yesterday
Yes.
only.
Just
Previously,
Mr. Cord, let them come back on Monday.
But as you
But is there an urgency?
But, no, I tell you, Lordship, the matrimonial suit was dismissed by the lower court. So it's a question of, Lord, expediting the appeal because
That is the application.
That is, Lord, the application because
No, stay of what?
I cannot ask for stay. There's this the suit has been dismissed.
We'll dispose of this application. We'll treat this to be an expedited application. We'll say there is no scope of grant of stay because it's a. We'll dispose of, pass the usual directions for paper book and all.
Yes, and I am saying, Lord, if your Lordship can kindly, Lord, expedite the matter because.
Yes, we are passing all those directions. Special messenger cost and everything. Service dispensed with.
And the my learned friend is really anxious that there are certain exhibits which are, Lord, in the name in the region of electronic records.
Right.
So, Lord, those should be, Lord, brought, Lord, with little expedition, because there may be, Lord, keeping them there with the damp and all, this evidence might.
Very well. The present appeal has been preferred by the plaintiff husband against a decree of dismissal of the appellant's suit for divorce. For the next para, although Can 1 of 2025 has been filed for stay of the decree, comma, we are of the opinion that no useful purpose would be served in staying the operation of a decree whereby the suit itself has been dismissed. Full stop. Accordingly, Can 1 of 2025 is disposed of by directing the appellant by directing that the trial court records shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. Full stop. Since we are apprised that some of the evidence is in the nature of electronic evidence, comma, it may be ensured by the it shall be ensured that the said evidence is properly preserved in order to enable this court to take up the appeal and decide the same appropriately. Full stop. Next para. In view of the appearance of the respondent through her learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for hearing, inclusion in the list as and when the same is ready for hearing.
Much
Thank you. This অনেকগুলো কি বলেছে অনেকগুলো ইলেকট্রনিক জলে ধুয়ে গেল অর্ডার দিয়ে দিলে ভালোই
22 minutes.
Yes,
For the appeal. The defendants in the suit for partition, the appeal before your lordships, my lord. The preliminary degree has been granted, my lord, in favor of the my lord plaintiffs therein.
Usual order, serve notice and come back. It will continue, but no final decree. The present appeal has been preferred against a preliminary decree of partition. Full stop. The trial court record, the trial court shall continue with the final degree proceedings, but shall not pass any final decree without the prior leave of this court, comma, during pendency of the application. Full stop. The appellant shall serve a copy of the application on the respondent, indicating that the application shall be listed for hearing in the monthly list of December 2025. Full stop. The appellants shall file an affidavit of service to that effect on the returnable date.
Yes.
I am for the defendant appellant.
I am for the respondent number 3, my lord.
3 only.
3 only, my lord. But without order, notice has been served.
Since you appeared, you cannot take that point, but on the others, we'll direct them to serve.
My lord, there is first, my lord, there is delay.
Condemnation of the serve and come back the rest.
But I have served.
No copies.
There was a direction.
No.
Then that is not good.
But difficulty is, my lord, only what I am.
Matrimonial.
No, the partition suit and my execution has been fixed, my lord, for taking peaceful possession on 27th of November.
You settle the letter. Mr. Basu will write the letter, you settle the letter. Like the memorandum. The letter to be given to your learned counsel in the court below, which will be placed.
My lord,
all pass an order. Some order will be there on record. Direction.
All steps have been taken.
No, but now we direct you. There will be an order of the High Court directing you to serve copy.
Let there be no stay of the execution process.
No.
Execution order.
What is the delay? What is the number of days of delay?
It is
4
about
years.
4 years.
No.
About 4 years. My lord, kindly.
You would wait for so long. You are waiting for the execution. Now you are
No, not that fact. My lord, preliminary degree 1/4 share was declared. It is not disputed, admitted by all the.
This is against final degree.
It is against final degree regarding allotment. Allotment, my lord.
You waited for 4 years till the execution case reaches culmination.
No, my lord, earlier I also a revision application was filed.
The commission was.
No, Mr. Madhu, you serve copies on.
Some protection. I have served. I have already served.
No, that was not by order of court.
No, that's true. But nowadays, it is only for.
No, nowadays, no.
But I
Instead of rule, we have substituted rule, Mr. Mahato, you know better. we have substituted rule by direct service through post. But prior to it's unknown to law that prior to direction of court, you can serve and come back. If they appeared, you are lucky.
Yes.
But otherwise, no. None appears for the respondent numbers 1 and 2 at the time of call, although the respondent number 3 is represented by counsel. Who's up next para? The appellant shall serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondent numbers 1 and 2, indicating that the application shall be listed next on November 24, 2025, when an affidavit of service shall be filed by the appellant.
So for execution, kindly give some observation, man. But otherwise, they will take possession.
We waited for 4 years, no. 4 years, if it was some days, Mr. Mahato, we might have considered. 4 years, no, definitely. We're not even sure whether we'll allow the application.
But the commission report has been filed, my lord, during COVID.
You
And,
waited
my lord,
for
from the order sheet, my lord, will find. My lord, there is, my lord, if your lordship kindly.
Participated in the suit.
Yes, but suit in the party.
What prevented you? What is the ground of
final, when my lord, final degree proceeding was going on, the commissioner was there, the COVID period was there.
So what?
My lord, it was not done.
After COVID period,
Yes, my lord,
they kept track, you could not keep track.
Commissioners, that is the difficulty, my lord. And another thing, my lord,
after 4 years, you don't have any entitlement to get.
My lord, from the record, my lord, from the order sheet, I shall show your lordship. My lord, kindly see 1 second.
No, no.
And another thing,
No,
my lord,
no.
kindly allow me to file the final decree of the.
Leave is granted to the learned advocate for the appellant to file the certified copy of the final decree in the department in the meantime.
No, my lord, here and now shall stitch it, my lord.
Leave is granted to the learned advocate on record for the appellant to file the certified copy of the final decree along with the second judge's copy.
Both, I have.
During the course of the day.
Yes, immediately. And my lord, returnable date, my lord.
24th.
24th, today is. My lord, even before that, I can.
You can't. It won't come back.
But others are with me.
Which area? This is
Midnapur. But my others are with me.
Midnapur within 1 and 2 are with you?
Yes.
You are a plaintiff there?
No. But the one is the plaintiff.
One is plaintiff.
One is plaintiff.
But
final
it's a
decree,
collusive suit.
Final
They
decree
won't
was, no. Final decree was sought for by the defendant.
Plaintiff 1 was with the defendant.
Well, defendant number 3 filed for final decree.
He has no appellant has no locus standi
to
file the suit, my lord.
To
file any objection. Already.
Mr. Mahato will keep it on 10th. Sorry, we'll keep it on 17th then.
17th, man.
24th, 17th. Have a letter written by someone to you that he has instruction to appear and give a copy, and then we'll take that as good service. You can do that by tomorrow. Mr. Kormakar is smiling, so his chamber can be engaged also. But it will be a bit costly. Better go to someone less expensive. Yes.
But I picked you up for the. Oh, I'm sorry.
Your prayer is refused, Mr. Kormakar.
For the appellant, my lord, there's a section 5 application, my lord, substantial delay. So not served, not yet served. But what happened, my lord, my suit was dismissed under section 10. This was a subsequent suit. Yes, section 10 of the CPC. But it has been dismissed, my lord, on that ground. That previous suit is pending, but my lord, my client, instead of preferring an appeal against that order, because that is a deemed decree, review was filed. Review was pending for 6 years.
Review was rejected.
Review was rejected, saying that there is no ground of review. I challenged by way of a revision that review order. The court said you prefer challenge the main order. So the entire period I was in litigation. But I have not yet served. Kindly allow me to serve the section 5 as well as the
Section 10.
Section 10. Lord. Kindly see the order, my lord. Order is that page 38.
There's some defect. This the time, but that is a defect.
That is one. The other is not the in the certificate copy. The date of the order is not mentioned. So we have to get us another certificate copy. We shall not in the
that
meantime,
you can or we can directly. That will do later.
Initial suit was filed. An injunction. Then they will enter into the property.
Are you sure on section 10?
Section 10.
What are you saying?
This is what happened, my lord. Lordship sees from the memo, my lord. I filed a subsequent suit with an additional pair of recovery of possession, but the other pairs are common. Section 10 was filed. No, section 10 was not filed. The matter was heard. Court suo motu dismissed under section 10. Interesting. 38. Page 41 of the application, my lord. Section 10 court has dismissed. I have never seen anything like this.
Serve copy of what can I say?
Both the applications, my lord.
Yes, yes. Serve both applications and memos. The appellant shall serve copies of Can 1 of 2025, Can 2 of 2025, as well as the memorandum of the appeal on the respondents, indicating that the applications shall be listed for hearing on November 24, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Well, item number 25, my lord, I am for the plaintiff appellant, my lord. The defect is, my lord, the plaintiff number 1, 5, and 7 is dead. The heirs are already on record. They have not been, no leave has been taken, my lord. In the appellate court, my lord, the substitution application has been allowed and they have been made parties. Therefore, my lord, this particular order is, my lord, can be ignored because the parties are already in this decree.
No, the corrections have been reflected in the decree. In the decree,
the parties are there, but it has not been expunged. Therefore, my lord, it has to go down for expunging the names. 1, 5.
so the decree has to be corrected.
Yes.
But your memo is all right.
Memo, the parties are there, my lord. And second is the respondent's name has not been properly serialized. Therefore, my lord, it has to be sent down. These are the defects.
That you have corrected already. There is signature. The certified copy in the
appellate court. Appellate
court. Oh, that also in the decree.
Yes. The appeal court, my lord, dismissed the suit holding.
No, I don't understand this endorsement of this sample report. Appellants 1, 3, and 7.
My lord, tell you, lordship, what happened?
Their legal heirs and representatives are made party in this appeal. They were not parties. They are not substituted in the trial court.
Trial court, my lord, after that.
In the appellate court.
Appellate court, my lord, the decree has not drawn up because the suit was dismissed on holding that the appeal court it's not within the pecuniary jurisdiction to take out the matter because the suit is valued at 10 lakhs. And therefore, the appeal court proceeded with the matter, then dismissed, holding that it doesn't have the pecuniary jurisdiction to.
But still, a decree is to be drawn up.
Yes, the decree has not been drawn up. Therefore, my lord, we have challenged the trial court. I advise my client to challenge the trial court decree because this decree cannot be challenged within Section 5 application under Section 5, Section 14 of the Limitation Act. But therefore, my lord, these two applications to serve.
No, appellate court did not have pecuniary jurisdiction. That's
yes, my lord.
That you are convinced that it did not have. This court has jurisdiction.
Yes, because 10 lakhs.
That's why you have challenged the trial court decree.
Trial court 1,50,000, my lord, Section 21 of the Bengal Civil Code Act. Therefore, my lord, I advise my client to challenge the decree of the trial court and file an application on Section 5 with an application for injunction. That application, my lord, we have filed.
No, regarding the first defect, 1, 3, and 7, they have died. Their heirs are
already on record.
Here.
Yes, already.
The trial court also they are on record.
Already on record. In the appeal court, my lord, there have been substitution in the trial court and in the memorandum appeal, my lord, they have been inserted. Therefore, my lord, after these, my lord,
then in the suit decree it won't be reflected.
No, it will be reflected in the appeal court judgment. The appeal court has dismissed the suit holding that is not maintainable.
But you have not challenged the appeal court judgment here.
No, I have challenged it since
you have accepted the appeal court judgment that it does not have
that's the reason, my lord, we have filed this appeal.
So no, but then the stamp report is correct. Insofar as the trial court is concerned, there is no reflection of the heirs.
They died.
There was no scope.
In the pendency of the appeal.
They died in the therefore in the appeal courts, in the trial court's decree, there would be no reflection of that.
That is the reason.
So then you have to seek an application, make an application for leave. Because they were not parties to
the trial. Lordship was saying that I have to make an application.
The one-page application allow that.
Order 41 Rule 20.
Make it with the 2-page application will allow that and take up your other applications.
Then, my lord, kindly keep it on WhatsApp walker. My lord, this is for Uttar Dinajpur. That is the difference. But if your lordship kindly directs me to serve and
because technically, I mean, we are not very technical on this, but even then,
well, I shall be doing it. Well, in the meantime, let me serve a copy of this application with this section. But kindly do that.
Well, the appellant shall serve copies. The appellants shall serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondents.
This is suit for partition, my lord. Only, my lord, 24, 25, and 26 different number. That is a respond number has entered appearance. But since these are suit for partition, if your lordship directs me, I have to serve all the respond. I do not know.
You'll be bankrupt by the time the matter is
Yes,
over.
my lord.
You, your clients,
Everything, my lord.
the court
What
even
to
may
do?
become
Well,
bankrupt.
properly, there is no proper advice, my lord. What to do, my lord? These are poor clients from.
Yes, you can fully appreciate.
So, my lord, I have.
Mr. Mr. Ghosh, what does your client do? The one who.
They are cultivators, my lord. These are only.
So we are granting oral leave to prefer appeal. He need not file an application.
I'm grateful, my lord.
But that will create a bad precedent. That is a difficult.
I'm grateful, my lord. This type of people.
Now, this type of people we are giving the relief, but other type of people will also now come and ask for the same relief. We cannot say no.
My lord, I told you last, my lord. What cultivators from the
Learned counsel for the appellants submits that the present appeal has been preferred against. What is the impugned decree in the trial court?
My lord, if you last, can you take my memo, my lord? It is judgment dated July 14, 2022.
Preferred against the dispute. What sort of suit did you file? Partition suit.
Suit for partition or dismiss in spite of my producing my LR record of rights, my lord.
কি বললাম appeal ariser has been preferred against the dismissal of a partition suit filed by the appellants. For next para, initially, due to erroneous advice, an appeal had been preferred before the district court, which was subsequently dismissed due to lack of pecuniary jurisdiction. As such, some time was lost in the during the pendency of the appeal. Although some of the appellants, being appellant numbers 1, 3, and 7, had died in the meantime, their heirs had been substituted. Their heirs had been substituted in the appellate court, and their names were duly recorded in the appeal. However, the appellants were subsequently advised that the learned appellate judge was justified in holding that it did not have peculiar jurisdiction, and as such, the present appeal has been preferred against the main decree of the trial court itself. Next para, however, since the demise of the said appellants occurred during pendency of the appeal, the name of the heirs of the deceased appellants were not reflected in the decree of the trial court. Accordingly, technically speaking, an application for leave to prefer the appeal is required to be filed. Next para. However, keeping in view the financial stringency of the appellants, who are primarily cultivators, and the fact that the heirs of the deceased appellant numbers 1, 3, and 7 were already impleaded in the appellate court, we are of the view that we grant leave to the appellant appellants, including the heirs of the original appellant numbers 1, 3, and 7, to prefer the appeal on the oral prayer in that regard made by learned counsel for the appellants. The appeal is treated to be cured of the defect in that regard. Insofar as the certified copy, insofar as the error in the certified copy of the impugned decree of the trial court is concerned, the decree shall be sent down after the disposal of the present applications. Next para, the appellant shall serve copy ke aage bollam na bolini 1 and 2 te serve na bolini the appellant shall serve copies of can 1 of 2025 and can 2 of 2020. Who contested?
24, 25, and 26.
Can 1 of 2025 and can
the memo it is 23, 24, and 25.
23, 24. Can 1 of 2025 and can 2 of 2025 on the respondent numbers 23, 24, and 25, who are the only parties who contested in the trial court.
Oh, my lord, 1 minute, my lord. It will be 24, 25.
Number change who are the only defendants who contested in the court in the trial court. The service on the other respondents is dispensed with for the present. The applications shall be listed for hearing next on In the monthly list of December 2025, which of the appellants shall file an affidavit of service on the returnability?
26. Hello, it will be 24, 25, 26.
ঠিক আছে 24, 25, 26.
The matter is returnable, my lord.
Returnable monthly list of December.
As you lord.
December.
As you lord. I'm grateful to you.
Thanks.
The defendant plot is the appellant before your lordship plot in a suit for specific performance.
What is the defect, Mr. Karma?
The defect.
You would not get the time to check up, but your engineer should.
Eta 21 হবে।
Deficit court fee has been paid, but
yes.
Classification of the appeal in words, what about that? Memorandum of appeal from decree. You have to correct that. What decree?
Original decree. It has to be original decree.
What else?
The original.
Let us see.
And Lord, the other one is perhaps the
Calcutta case number.
Yes,
in the
that has to be 2021 instead of 2025. So grants me leave, Lord.
Right now, yes. Leave is granted to the learned advocate on record for the appellant to rectify the memorandum of appeal in terms of the additional stamp reporter's report dated November 3, 2025 during the course of the day. Yes, what is the
may I find that is not my learned.
affidavit of service will be kept on record. Right.
The suit is for specific performance of an oral contract of a land. Lord, the plaintiff case is that I am Lord, the defendant is the development officer, and Lord, the plaintiff is the agent under him.
Development officer
of the LIC, Lord, Life Insurance Corporation.
How does that matter?
Lord, that is the plaintiff case. That because of that, I was exercising a dominant position for which I forced him.
No, he was a development officer. You are the.
I am the development officer. He is the agent.
Oh, he's an agent.
Yes, and based on that, I forced him or coerced him not to enter into a contract with me to purchase my land, which was not sellable at that point of time. He paid me money. Now, Lord, after about 10, 12 years, Lord, when the land was sellable, became sellable, Lord, then he wanted to enforce it. I refused. That's why specific performance.
But
that's
if
the plaintiff case.
Into doing that, then why is he trying
That's the plaintiff case. That's the plaintiff.
The suit has been decreed.
Suit has been decreed. The suit, the learned trial judge proceeds on the basis as if there was already a existing contract, and by back calculation somehow, Lord, the conclusion has to be made. Lord, that is how. What is the finding of the learned trial judge? Dominant
Oral
position
contract of 14 years back.
Yes, 2011.
So how do they overcome limitation? Because it was not in a position to.
Not,
land was not sellable.
Yes, land was not sellable, and immediately cause of action was given in 2021. Immediately after 3 days, the suit was filed. That's on refusal. The refusal was after 11 years of paying the money in 2012. Last of the installment, as per the plaintiff case, was paid in 2012.
Money receipts were produced.
Money receipts produced. And my case is not that it's a loan taken, out of which I had also repaid back 50,000. That was also taken on record.
Those
nothing is not
those
discussed.
receipts are there.
Yes, not my bank account is there. Exhibited.
Payback.
Exhibited. And not nothing is taken on record. Nothing is considered. Not the only one thing is considered, that he is a poor man. He used to trust.
Development officer is a poor man.
No, the agent.
You are the developer.
Yes. Agent is a poor man, and I was in a position to coerce him. So I did it. He paid me money. That's why now I have to honor the contract.
When was the last payment made by them according
2012. That's on
suit of 20?
Suit of 2021. Limitation not discussed, not dominant position. How exercised? No proof, nothing given, no evidence. Just not presumption. This could have happened. Thereafter, Lord, oral contract, Lord, evidence given by his son and his brother. None else. No, Lord, corroborating evidence. No, Lord, other, Lord, circumstantial
Yes,
evidence.
Mr. Mahathir, we are granting stay till disposal and direct them
So far the possession is concerned, my lord, I
And
mean,
only one thing, taking the advantage of Lord, this
my lord,
decree,
the oral
they have
contract,
put a
oral
padlock in
conversation.
the Lord tin shed. So Lord, for the timing, I have also asked for prayed for Lord injunction that not to be dealt with, status quo to be maintained as regards the possession nature
You
character.
have asked for is not disturbing the peaceful possession of the petitioner.
Yes, and also Lord, in the
Your
meantime,
position-
they have done that.
So possession is risky. I mean, we won't.
That's the position, Lord. I
For
must
the
Lord,
oral
indicate
conversation, my lord, over by mobile phone that has been produced before the court, that has been exhibited.
65B complied with evidence.
I have an objection to that also. 65B, not in the sense that it should have been done.
Yes, obviously.
And their admission regarding payment is there.
So regarding possession, we are directing status quo, Mr. Kormokar and Mr. Mahato, and you will not create any third party interest. The usual.
I shall not. I shall.
Very well. The present appeal arises out of a decree of specific performance. Upon hearing learned counsel for the parties, we find sufficient prima facie case for an injunction having been made out. Next para. Accordingly, the respondent and/or his men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and not creating any third party interest in respect of the suit property during pendency of the appeal. Both parties shall maintain status quo as regards possession also during pendency of the appeal. In view of the appearance of the respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned counsel for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Prothome affidavit of service filed to be kept.
Lord, the decree also needs to be stayed, Lord.
What?
The decree of specific performance.
There shall be stay of operation of the impugned decree till disposal of the appeal as well.
As far as concerned,
yes,
fee is in my favor, but my lord, deed has not been executed in my favor. Specific performance of contract.
So we have state operation of that.
My lord, that's true. But my lord, so far the injunction relating to transfer is concerned, but they should also, my lord.
That's what
should not
transfer, my lord. Status quo as regards both the parties.
We have restrained them only for transfer.
So the transfer,
But there is no allegation that they are trying to transfer.
my lord, they have the title deed. They are the decree is in my favor for executing.
Okay, injunction.
Both the parties. Both the parties may be restrained.
Respondent shall remain restrained by an order of injunction from selling, transferring, alienating যেটা লিখেছি ওটা both parties shall remain restrained.
Mine. I'm good. Read.
Number 27.
My lord, this FMA is arising.
This is the matter where you appeared in the first call but did not appear in the second.
Yes, my lord.
You came running in with Mr. Parthopratim Rai.
Yes, my lord.
Yes.
My
You
lord,
move the button now.
My lord, this matter is arising out of a order of my lord remand.
Very good.
My lord.
What was the suit? Just give us the background.
My lord.
You are the plaintiff.
I am the plaintiff, my lord. I filed suit for declaration of title and permanent injunction, my lord.
Yes.
Against that was decreed in my favor, my lord. Against that order, the defendant respondents, my lord, filed title appeal, my lord, and the learned appellate court remanded back that before the trial court, my lord, for taking evidence again, my lord. And against that order, my lord, this appeal is.
So why do you say it is a bad order? I mean, what is the wrong in the order? It is a ground of appeal.
My lord,
There is sufficient evidence to decide by the appellate court.
Well, that was already, my lord. Everything was already done, my lord.
What are you asking for now? Stay of the suit.
Stay of the order of remand back, my lord. Of remand.
Not stay of the order of remand. That we will grant stay of all further proceedings in the suit.
Yes, my lord. That is okay.
Very well. Your full name is what, Roy?
Samrat Chakraborty, my lord.
Chakraborty.
My lord, I believe, my lord, this matter also on previous occasion, my lord, in another matter, my lord.
Yes.
Your lordship directed that the applications, my lord, arising out of this kind of, my lord, order of remand, my lord.
That would be single.
Yes, my lord. That.
Thank you for reminding us. Extremely sorry. Yes, you are. Since the appeal has been preferred against an order of remand, the matter is required to be heard by a learned single judge of this court, who shall accordingly let the matter go out of the list for lack of determination with liberty to the parties to mention before the appropriate learned single judge having determination. Thank you. We had just forgotten.
Much obliged.
Number 28. 28, Lordship, I appear for the respondent.
Respondent. What is the appellant? Get hold of the appellant. No, it's 50-50. On the last occasion, you shot at them.
They were also not represented.
I am seeking a day's of representation. I'm extremely sorry, my lord.
Why? You are generally ready.
Yes, I'm generally ready.
the
I'm
brief or
not
some-
having the brief, unfortunately. And Shoroji is leading me in this matter. He's engaged in 2038 or something.
Tomorrow.
I'm
On
extremely
the
sorry.
prayer of the appellants, the matter is adjourned for the day.
I'm grateful.
But now, if you don't appear, then
I will bring the brief and I will do the matter, my lord.
even if you don't bring the brief to the matter.
I will do that, my lord. Grateful.
At earlier occasion on 16th of April, your lordship directed me to amend the cost title and the prayer portion.
You've done that?
Yes, I have also served the copy of the application, but this is the application for visitation right. Let the
appeal was formally admitted.
Yes.
Achha.
Yes.
Visitation right.
Invitation might yet on.
You're the father.
I am for the father.
Age of the child?
He is now 12 years.
The male
12
or
years.
female?
Even
Male.
female child. Female child.
Who are the other parties?
Other parties is the mother, and your lordship directed, since the mother is residing in New Delhi, the minor godchild is residing with her parental home,
Grandparents.
and they have been
Maternal grandparents.
They have been added as a party. Well, kindly come to page 19.
Section 5 has to be allowed first.
Allowed.
Oh, this stage.
Yes, your lordship directed me to
What
serve
I
the
take
copy, and the learned trial court also given the
in the trial court, what is you had filed an application for custody.
Custody.
Acted case.
Acted case.
So what happened? Why was it refused? You were given visitation by the trial
Yes, even then the mother is not giving the permission or the right to visit the minor child, and the father has not visited her child for the last 5 years. Even
it was vague. Actually, the trial court permitted whenever the respondent will allow petitioner to meet the child and accept gifts whenever the petitioner approaches her.
My lord, kindly
that is a bit vague. We'll structure it. We'll put a structure to that. It's easier for the
for
child.
the time being, my lord, kindly come to page 52 onwards. 52 only.
Now you are praying for
I'm
visitation
praying
to
for
child.
visitation right.
Grant that. Probably they would also not be in principle because they have not filed an appeal. But we'll structure it, not whenever you please.
Earlier,
Lordship, the date and place, we have no problem.
well, earlier occasion also granted, but the father was assaulted by the brother-in-law, and that's why he has to lodge a 2 police complaint. Okay, my lord, kindly come to page.
Assaulted by the brother-in-law.
Yes, by the brother-in-law.
Is residing with them also.
With him.
What does it do? He's in wrestling or something.
Yes, he was restrained from visiting.
He's in wrestling.
Probably.
Not restrained.
Page 76, my lord.
He assaulted and you accepted that. Why didn't you assault him also?
Twice occasion. Probably the brother-in-law has died. Probably. In the meantime.
If he has died, then you are safe now.
Well,
you are safe now. We can appoint a special officer to protect you when you.
Yes.
Yes, we'll appoint Mr. Shonok Bhattacharya as special officer to accompany you, to save you from your brother-in-law, so that he cannot assault you.
For the timing, so far as my information is concerned, probably the brother-in-law has died.
So you are safe now. And Mr. Bhattacharya is also safe. So very well. So yes, when does it suit you? I mean, she must be studying in some school.
Yes,
my lord.
She is studying.
Yes,
Saturday, Sundays would be weekend.
Yes, my lord. Yes.
So yes.
Yes, means for visitation, it will be. I think it will be better if it is in court premises on Saturdays.
Not court premises.
Not.
Somewhere else.
No.
Court premises is not congenial for a
And
child.
my lord, if required, before visiting, the father will give a notice to the.
Yes.
No.
Because your lordship, first of all,
No, we'll keep it.
and I am also your lordship a working woman. I am staying in my place.
You are in Delhi.
No.
Delhi.
I'm not in Delhi.
You are in Calcutta, itself.
Yes, your
Well,
lordship.
that has been recorded in the order itself.
In the order, it has
I
been.
am staying at Calcutta, your lordship. I am worked at I am working at Delhi and working from home, your lordship. That is
the nature of your job.
IT. Means in IT, there's a working in home.
So you have to go there occasionally.
And the husband, your lordship, last known, your lordship, he is posted at Jharkhand, your lordship.
Now he is in Kolkata.
And
Very well. We can make it a public place. It will be a weekly visitation. Weekly visitation every Saturday, if that suits you. Saturday afternoons, 2 hours. in an open space. Where does the child reside?
Yes, I'm not place your lordship. There's in the custodial.
It is Kachrapara. Kachrapara, not in Beachwood, within the jurisdiction of Beachwood Police Station.
We'll keep it day after two. We'll keep it on Monday. Both of you agree to a place, either a park or a mall or something like that. It will be Saturdays 3 to 5. Tentatively, you agree to a time. If you agree, that will be best. Otherwise, we'll make it an order of the court. But regarding the place, please just agree to a place if you can.
Every Saturday, lordship means.
You have not challenged the order. The order says whenever he pleases.
Yes, yes. Oh, okay.
So we are without an appeal on your part, we are modifying the order. In fact, the present application has been filed for modification for visitation rights for visitation by the appellant father of the 12-year-old daughter of the parties of the appellant and the respondent number 1. Full stop. Next para. It is submitted by learned counsel for the appellant that the mother of the child, that is the respondent number 1, resides in Delhi for her work, whereas learned counsel for the respondent submits that the mother, although engaged in a job in an institution in Delhi, it's a company, in a company at Delhi, works from home primarily from Kolkata and occasionally visits Delhi, and as such is with the child in Kolkata now. For sub next para, be that as it may, it transpires that even in the impugned order, the learned trial judge permitted the appellant to visit the child as per his convenience. Full stop. However, we are of the opinion that a structured visitation, preferably every weekend, for certain particular hours at a public place congenial to the welfare of the child would be suitable. Full stop. Next para. In order for the parties to agree to a common place of visitation, we adjourn the matter till November 17, 2025, or should we keep it day after tomorrow? No, day after tomorrow we take up appeals first. So
Monday.
Till November 17, 2025, full stop. It is expected that in the meantime, the parties shall agree to the venue of visitation and, if possible, to the days and hours of visitation as well. We are indicating Saturday 3 to 5. That's negotiable. You just agree between yourselves. If you can come to a conclusion, it will be an agreed order. It will be best for the child. Yes. Admission high. Application. This has not yet been admitted formally.
No, not there. So only there was
application. We got application. Over the application appear kochilo. It is appearing in the other bench on
application.
Copies were directed to be served.
Milord, not served, Milord.
Thank God.
It was sent. It has been not been served, and Milord, the suit itself is running.
No, you are. The direct
Milord,
what is the matter about?
Yes, Milord, the matter is, Milord, for
probably the intention of the bench was to dispose of the entire thing.
The entire thing, Milord. What happened, Milord? This is a suit for recovery of money. Their lordship, Milord, when I moved the matter, their lordship's, Milord, view was
this is good service.
No, not that's what, Milord, I said, Milord. It has not been served, Milord. I have, Milord, the order of the learned trial judge, which says that the suit is running ex parte against all the defendants.
What have you challenged?
Yes, this is refusal to pass an ex parte ad interim order of injunction in a suit for recovery of money. Milord, this is a case, Milord, where suit was filed earlier. But
your suit?
My suit. Now, Milord, but Milord, after some times, Milord, we found that the defendants, although they are avoiding the Milord court, but they are, Milord, selling, Milord, they are trying to sell, Milord, their several assets. Now, Milord, if, Milord, ultimately I get a decree, Milord, and there are no assets, Milord, it will be, Milord, only
in the nature of order 38 to 5.
Order 38
attachment before judgment. Standard should be higher.
then it should be higher.
You have to show that they're trying to
But my lord, they,
misappropriate or sell the property or
yes, my lord,
part with the property.
but the order says
Even attachment before judgment footing.
but the order says, my lord, there is a my lord, proceedings pending before my lord, the company national my lord, company law tribunal. That's why the jurisdiction is my lord, totally before the tribunal. Money suit does not lie. Now, my lord, for that, my lord,
What is pending? CIRP corporate.
yes.
Then
No, my lord, kindly comes to my lord.
moratorium operates.
Can 2. That is an application, my lord, for additional evidence, my lord, which we could not produce, my lord, before the learned trial judge. Can 2. Kindly comes, my lord, page 9. Page 9.
Yes.
My lord, ultimately, my lord, kindly see page 10. It's several my lord orders were passed. Ultimately, paragraph 3 with the above directions, both such and such shall stand disposed of. My lord, we could not produce, my lord, this before the
What is disposed of?
my lord, the company
Applications are disposed.
yes, the CIRP.
CIRP itself is not. How can it be disposed?
The CP, yes, IA and CP both shall be stands disposed of. IA and CP, paragraph 3. Interlocutory application and company petition.
No, there was a resolution. There was something was accepted. A resolution plan was accepted. What sort of thing is this?
Pages CIRP against the corporate debtor by order dated 9th December 2021 is hereby closed.
Appointed in this matter seeking withdrawal of the CP. Oh, withdrawal of the CP.
Yes.
Why?
Then Miller kindly see page 11.
Settled the matter amicably. It was on settlement. Both parties have settled.
Yes, Miller, I was not there.
Oh, you were how?
I was not there. Miller, kindly see page 11, Miller. This is
so you say so. This was the only ground of.
Kindly see, Miller. There were 2 grounds. One, Miller, there was an agreement. There was which Miller, which was sent to us. We signed and gave it to them. Now we filed that copy of the agreement.
For what?
Agreement, Millard. What happened, Millard? We took the agency of this defendant number 1 and 2. Millard, their business is the
interior decoration or something.
Interior
furniture.
Exactly. They will. We will give them advance money. They will give us the products. We will sell. Millard, this was the agreement. Now, Millard, learned trial judge Millard refuses Millard injunction on 2-fold grounds. One is the agreement is signed by only one of us. It's our signature was there. Their signature is
their
not.
signature is not there. How can it be an agreement?
Millard, corporate Millard, kindly see Millard the Firisti documents we have filed before the learned trial judge. They have given us distribution code and even Millard tax invoices.
That was acted upon.
And secondly, Millard, this pendency of CIRP. Millard, we could not produce before. We did not have this information about CIRP at that point of time when injunction application was heard. Now, Millard, that's why Can 2 has been filed before your lordship.
So what are you expecting? An injunction at this stage you have to avert. Are there averments that they're trying to dispose of?
Millard, kindly take some, Millard. That is Millard annexed, Millard.
Can I be sought? Let us see the injunction. Restraining them for transferring third party suit property. How can there be suit property?
No, non-suit. That is your
fair.
And suit property is not. That would be the non-suit property. If your lordship,
you have to give the list of their assets and all these things.
That is
schedule has to be
kindly
there.
comes to Millard the injunction application, Millard, page 70. Page 70.
Yes.
Kindly comes to Millard the prayer which is at page 21. Therefore, it is prayed that your petitioner would be pleased to pass an order of temporary injunction to restrain the defendants from transferring and the sale or dispose of the scheduled property to third party during the pendency of the suit, and or to create any encumbrance in the scheduled property during pendency of the suit in any manner whatsoever, and or pass to an interim order of injunction in similar terms or any other relief as the plaintiffs in law and equity.
Yes, the necessary averments are also there in para 10 of that.
10. And schedule is, these are their properties. And Mareva injunction, Millard, it is. That can be. And Millard, order sheet.
You are a sort of franchisee or agent?
Agent. And Millard, this is the order sheet of the learned.
You have paid them certain amounts.
Yes, I'm showing
the nature of your job. Your job profile was what?
They will supply us those Millard products. We will sell it. And for that, we have to give them not advance payment. Well,
They did not supply the product.
At all.
That
At
is
all.
what-
Well,
no product was supplied.
No, at all. Well, kindly see, these are the Philisti documents. Kindly see the next page also. These are the tax invoices.
These are part of the record.
Yes, yes, Philisti documents. Yes, please.
Description of goods are there. Tax invoice.
Invoices raised. We had not got a single product as of today.
Invoices were raised. The presumption is that they had given the products.
Actually,
Biharilal is you.
No, we are Rungchan, the interior.
So how did you get the tax invoices?
These were sent by WhatsApp.
What is this WhatsApp message? Your promised time is over. When are you going to deposit the amount? Who is going to deposit the amount? You are to pay money. First week of April has passed, didn't get anything. Your annexure.
Oh, very well. There was a telephonic conversation between the two parties.
You had to pay the money.
No, they said that they will return back the money. And if your lordship would kind enough to see the second last page of the impugned order.
Yes.
Kindly see, the second last paragraph. Three paragraphs. It is hard to believe that a prudent person who deliver a colossal amount of 15 lakhs only on the basis of virtual communication. Moreover, there is no material to draw the inference that the said amount of money was advanced in pursuance of that mutual agreement. It further transfers from a document filed on behalf of the plaintiff on 28th April 2025 that a defendant number 1, which is a limited company.
It was not only the CIRP then. The other
True, that's why.
The materials to prove the amount of money or advance money receipts were produced by you.
Money receipts, these are the tax invoices which were produced by me. Bank statements. Court says since the agreement is signed by only my client, therefore that is not a concluded contract.
Craft furnished quantity such and such. This is not a tax invoice. This is not a money receipt. We don't find any proof of that you paid the money actually. Should have annexed these things. But you should have annexed these things, Mr. Bhattacharya. Okay. Money receipts have to be there, otherwise we are not satisfied that you have paid money. It's a huge amount, granting injunction, restraining them from transferring their property.
Oh, yes, yes.
List of documents, item 4 is bank statement of payment.
Yes. These
And
tick mark
three is state
documents,
partner.
tick mark documents, 15 lakhs.
Why didn't you annex these?
This was,
These have not been annexed, but you have only annexed a list of documents.
the tick mark documents, if your lordship adds, this has been transferred to their account of 15 lakhs.
Where is the agreement?
Agreement.
This is the agreement. No.
No, agreement is
What the data?
that is also there.
It agreement.
17 June 2020.
Partner agreement.
17 June 2025.
But it's 25th November is there.
No, 17
November
17 June
21. Aizol. Before
25th
that,
November 2021, and before that
14th November 2024 is there. That's a special power of attorney.
no, this the agreement is entered on 25th November 20.
Yes, 25th November 2021.
Yes.
This is that agreement.
Yes.
You yourself have prepared the agreement and you have signed.
No, 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 it can't be, my lord.
Obviously you have prepared.
It has, my lord, been acted upon, my lord.
They never appeared in the trial court.
No, that is the, my lord, order sheet.
No, but
kindly see.
tax invoice is not money receipt, Mr. Bhattacharya.
My lord, my
Not
bank
convinced.
statement, my lord, kindly see the last part of the
Yes, bank statement, sir.
last two lines, my lord, or after ordered.
Expert. Expert হেরেছে ক্ষমতা আছে। ব্যাংক ট্রান্সফার গুলো রয়েছে। What is your explanation for unilateral signature by you?
These are, my lord, entire, my lord, business transaction. All proposals were, my lord, during the, my lord, just before, my lord, COVID, and, my lord, all by WhatsApp. All by WhatsApp.
Immediately before COVID. And the furniture business must have thrived during the pandemic for you to make these transactions.
That, my lord.
Not too credible, Mr.
This is there, and my lord, almost in a similar circumstance, my lord, coordinate bench of your lordship, my lord, at past, my lord.
What means you comprised of me and Justice Kumar? Then?
Justice Jyotirmoy Bhattacharya and Ishan Chandra Das.
Not binding. Cite the judge.
Paragraph 21 onwards.
ব্যাংক ট্রান্সফার গুলো রয়েছে সেটা ট্যানজিবল এভিডেন্স কিন্তু ব্যাকআপ করার মতো আর কি।
Paragraph 21 onwards, my lord.
Which is a relevant portion?
My lord, 21 on, if your lordship would kind enough to come to, my lord, 25, 26, 27, 28. May I place? এটা ডিস্ট্রিবিউশন করতে দেখিয়েছো ওখানে নেই তো না না দাঁড়াও ওগুলো 30
Here it was said the tests for attachment to judgment and injunction are different.
The 27, my lord, there is no absolute ban. Generally, my lord, courts say, my lord, 38.5, go file that application.
No, we are not saying exactly that, Mr. Bhattacharya. We are not
facts.
saying this is a 38.5 application.
On facts.
This is an injunction application, but we are saying that we are somewhere in between this judgment and the other view. I mean, we are saying that yes, it's a temporary injunction application, but higher standard of proof than injunction has to be satisfied because you are restraining somebody from disposing of his property when the property is not the subject matter of the suit.
Then they should have
The corporeal rights in the immovable property is not the subject matter of the suit. Your money claim is the subject matter of the suit.
And my lord, although my lord, my junior has given me a document, this I do not know why this was not produced before
No,
the
then
trial court.
we cannot
My
look
lord,
into
mail
whatever was
communication,
produced in the court below.
this was a distributor code, my lord, which was generated in our.
No, unless that is a part of the records, particularly since they are not here.
No,
We also have to protect their interest
So
because
that's
they're
why, my lord, order 41, rule 27, my lord, I had. Okay.
do that.
I had already there, can too.
Oh, it's also there. অ্যাপিলটা অ্যাডমিট করি ফর্ম মধ্যে অ্যাডমিট তো করবে ওটা যখন আসছে না তখন কি করবে বাট গুড সার্ভিস হ্যাজ নট বিন এফেক্টেড
Returned. It has returned to the sender.
Serve again will grant an injunction till disposal of the injunction application. Affidavit of service filed today be kept on record for despite attempts to serve, comma, as per previous direction of a coordinate bench, comma, service has not yet been effected on the respondent. Full we find from the copy of an order dated April 23, 2025, passed in the money suit in connection with which the present appeal has been preferred, comma, that the injunction application was proceeded to be heard by the learned trial judge, also ex parte, since despite exhausting order 5, rule 9, read with section 151 of the Code of Civil Procedure, comma, the defendants had not turned up in the trial court. For the next para, the present appeal has been preferred. This is the impugned order. The present appeal has been preferred against the said order whereby ad interim injunction was refused. Full stop. The brief conspectus of the plaintiff case is that the plaintiff is an agent of the respondents. Full stop. On the assurance of the respondents, comma, the latter being distributors of furniture, comma, the plaintiff paid huge sums of money, allegedly paid huge sums of money to the respondents upon invoices being raised in that regard. However, comma, the plaintiff alleges that that the end products were never given to the plaintiff at all. As such, comma, the present suit has been filed for recovery of the money which has been paid by the plaintiff to the defendant. Next para. On a prima facie reading of the impugned order, comma, we find that the learned trial judge, comma, while not granting any ad interim order, comma, did not assign any reason for refusing to do so. Next para. On an independent assessment of the materials before us, comma, we find that the plaintiff/appellant is equipped with certain bank statements as well as invoices which prima facie indicate that certain payments were made by the plaintiff to the respondents. An agreement has also been furnished before the trial court as well as before us. However, comma, the same is signed only by the appellant, and as such, much reliance cannot be placed at this premature juncture on the same. Next para, be that as it may, comma, in view of the transfers of money established prima facie by the plaintiff being explained by the agreement read in conjunction with the same, comma, we are of the opinion that a sufficiently strong prima facie case for grant of injunction has been made out. Next para, we are aware of the fact that in cases as the present one, comma, the tests even for grant of injunction under Order 39 Rule 1 and 2 have to be on a higher footing, although less stringent than Order 38 Rule 5 of the Code of Civil Procedure, comma, since the corporeal rights in the immovable property regarding which injunction is sought is not the subject matter of the suit directly, but the suit has been filed with a money claim. However, comma, fact remains that on the basis of the averments made in the injunction application in the trial court, comma, which have to be taken as sacrosanct for the purpose of consideration of ad interim prayers at this juncture, comma, it is evident that unless an injunction is granted, comma, the money suit, comma, even if it culminates in favor of the plaintiff/appellant, would be rendered toothless if the immovable property belonging to the respondents are transferred to third parties in the meantime, comma, thereby denuding the money claim of the appellant from any security. Next para, in such view of the matter, comma, there shall be the respondents and their main and agents and or their main and agents are restrained by an order of injunction from
Creating third party.
transferring and or creating any third party interest in respect of the property mentioned in the schedule to the injunction application filed in the trial court, comma, as enumerated at running page 21 of the present application, that is Can 1 of 2025, till disposal of the application. Full stop. The appellant shall serve copies of the injunction application and Can 2 of 2025, as well as a copy of the memorandum afresh on the respondents, indicating that Can 1 of 2025 shall be listed next for hearing on December 8, 2025, when an affidavit of service shall be filed by the appellant. এই পুরো যা বললাম তার আগে একটা করে দিও, in view of sufficient arguable issues on fact and law having been raised, comma, the appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. তারপর বাকি যা আছে but you have to hand over copies of this
Immediately.
judgment. You have not touched right now because we'll have to distinguish it otherwise. But this during the course of the day hand over. And this we are retaining.
Yeah.
Give 2 copies, Mr. Bhattacharya, of that.
Yes, definitely.
2 copies of that during the course of the day before they leave the court.
Yes. দিয়েছি।
এটা দিলে ঢুকিয়ে দেবেন। Next. Yes, Mr.
The video service person to lordship direction I have served.
Received?
Yes, my service has been affected.
He is with you. Service affected? What is the matter?
This is an application for injunction has been passed challenging the same, my lord. The defendant number 1 is the appellant before your lordship.
You want to make construction. They have been granted injunction. You say they have already made constructions in their.
Apart from that, my lord, if you logically consider the plaint itself, page 10, my lord, the letter is too small. I tried my level best to get it some enlarged. Micro Xerox is not available now.
Page 10 we can read.
No, my lord, no, it is. I have tried little bit to relevant portion. That
you send somebody before the law colleges, you'll get all sizes of
getting that no for the
whatever made to order, whatever size
that we know. My lord, we are all
before the examinations.
At the time,
this is a plaint.
This is a plaint. I am drawing lord's attention. So far, the first second paragraph, last line.
Numbers are not there. Those have been omitted.
Yes.
Anyway, we will follow this. Yes.
Last
here
line,
also the same thing.
Yes.
Second paragraph we can.
Yes. Dudal Mondal Pratosthanadi, my lord got it.
No. It starts with, the paragraph starts with.
The paragraph starts with RG Bonito Nalishi Sampatti. Say
that is all the paragraphs start with that. 2 and 3 both start with that.
Next, second one.
Acha, yes, let us continue. Yes.
Irfan Sheikh, Kalu Sheikh, Manik Sheikh, Dulal Mondal. My lord.
Yes.
তার নারী সম্পত্তি মালিক দখল করার থাকে নারী সম্পত্তি বহুদল করে আসিতেছেন নারী সম্পত্তি রাস্তার ধারে সম্পত্তি হতেছে বহু মূল্যবান সম্পত্তি হতেছে নারী তফসিল বর্ণিত সম্পত্তিতে ইরফান শেখ সম্পত্তির মালিক ছিলেন উক্ত সম্পত্তির মালিক মোহাম্মদ
What is the point? We are
yes that last line দুলাল মন্ডলের প্রাপ্ত স্থানাদি মানে গট ইট উমর আলী 6 পুত্র গোলাম মোস্তফা নুরুল হক মনিরুল হক আসাদুল হক আব্দুল আলী এবং আশরাফুল হক বিভিন্ন দলিল মূলকে খরিদ করেন
Mr. if you without looking at the papers, if you can repeat these names again, we'll grant you injunction. We'll grant you injunction. We'll allow the appeal. So what happened to these people?
Now they are the plaintiff. So the original owner is Dulal Mandal, from whom the
They have
plaintiff, the
purchased.
defendant purchased.
How are you? How are you related to them?
I am, my lord,
You are they are related to them or third party to the family?
I am, my lord, your lordship find Ashadul Haq. Plaintiff,
very
the
good.
defendant, my lord, they are all the
So then what happened?
Now, my lord, as everyone is deciding a particular portion of the property because the transfer has been effected by umorally by executing a deed.
Do they
given-
admit that in their plaint? That everybody is deciding on their portion?
Yes, up that your lordship find.
But rather they say এক্ষণে 1 নম্বর বিবাদী নালিশি সম্পত্তি রাস্তার অগ্রভাগে the better portion সমগ্র স্থানাদি মেন রাস্তা হইতে উক্ত সম্পত্তিতে প্রবেশ করিবার জন্য কোনরূপ কোনো জায়গা না ছাড়িয়া PWD roads এর স্থানাদি সহ. So you are encroaching PWD roads, you are taking the front portion from the main road and forcibly you are trying to make construction. How can we permit you that?
I am going to do that. So this is the allegation.
And this is at the ad interim stage. The ad interim injunction has been granted.
It was
Temporary injunction has been. So you have filed your objection?
Yes, yes.
Where is that? What have you stated?
11, page 11, if your lordship can you turn to paragraph 8.
Yes, 8.
That is at page 13, my lord, find. Everybody is due purchase the divided portion from the.
You could have held prayed for a local inspection.
Yes, that was also held.
Show us the report.
Report, my lord, will find, and the points for local inspection, page 19, my lord, will find.
Yes.
And my undertaking and
this is the construction ache kina?
Yes, after that my undertaking to complete the roof, and the report is at page 23. I am drawing lordship attention to page 24. Answer to question number 1.
We don't get from here the who is occupying which.
Yes, that your lordship find. 7টি বসত বাড়ি 12টি দোকানঘর একটি অসম্পূর্ণ নতুন পাকা গৃহাদির কনস্ট্রাকশন রয়েছে এবং নালিশি দাগের দক্ষিণ পূর্বে 6.3 স্থান ফাঁকা রয়েছে, পশ্চিম রাস্তার লাগোয়া 2 ফাঁকা রয়েছে, উত্তর দিয়ে পূর্ব পশ্চিমে বড় বড় লম্বা বাঁধ হয়ে গেছে। নালিশি দাগের শেষে পূর্ব দিকে বাঁধকাম রাস্তা দক্ষিণে পাকা প্রাচীর দ্বারা ঘেরা পুরাতন একটি দ্বিতল পাকা বসত বাড়ি আছে দেখিলাম। উক্ত দোতলা বাড়ির লাগোয়া উত্তর দিকে নতুন গৃহাদির অসম্পূর্ণ কনস্ট্রাকশন আছে দেখিলাম, যা পেন্ডিং অবস্থায় আছে। উক্ত কনস্ট্রাকশন ছাদ ঢালাইয়ের জন্য সেন্টারিং করা আছে দেখিলাম, ছাদে তৈরি শিক বাঁধা আছে। উক্ত কনস্ট্রাকশন পুরো
How do you know who is doing this?
Yes, apropos to this, one can consider my objection. This is there is no dispute regarding the construction. Here it is categorically mentioned উক্ত construction প্রাচীর এর ভিতরে অবস্থিত হয়েছে, because my case is that if you logically turn to my objection, page 13.
Yes.
So even if substantial, even if biologically logically considered, apart from that it is bounded by a boundary wall. Apart from that, substantial construction has been.
Boundary wall is for the entire property.
No, it is only for mine.
You have a boundary wall.
Yes.
Let it portion. So you say there was an amicable partition?
Yes, initially, and not amicable, it is demarcatedly transferred by umorally. Dulal Mandal to the sons of.
But by sale deeds?
Yes.
Gift deeds or sale deeds?
Sale deed.
Where are the deeds? You have produced the deeds.
Yes, we have produced. They have produced. They did not produce any deed.
No, you produced registered deeds showing that this property has been demarcated and sold by the original owner.
Yes, that is the specific case I made out also in my application.
How was it dealt with by the land trial judge?
Nothing
in the impute order.
If you logically turn to
You haven't annexed the deeds here?
Yes, yes, I should have. I should have. The Firisti is with me.
Of your case. Firisti, why didn't you annex the Firisti at least? We would get an idea of what you have annexed.
Well, this is the order impute. 2 pages. Nothing has been dealt with.
You could have disposed of the appeal itself if they were present.
That is why your lordship was pleased to direct me to serve notice upon the. I have done so because they did not appearing. That is the main. This is the order, my lord, on the basis of which nothing has been considered. Any principle.
But without fixing the appeal for hearing, we should.
My lord, if your lordship fixes an appeal, so I can serve another notice indicating the order.
We'll do that. affidavit of service filed to be kept on record despite service none appears for the appellant.
I'll make a
Respond.
supplementary affidavit by including the documents which I have relied upon with the court.
Respond on the prayer of the appellant, comma, leave is granted to the appellants to appellant to file a supplementary affidavit. Full stop. The appellant shall serve copies of the stay application, the memorandum of appeal, and the supplementary affidavit afresh on the respondents, indicating that the appeal and the application will be taken up for hearing together on the papers already on record on the returnable date. Full of the matter shall next be listed on December 8, 2025 under the heading application, with the understanding that the appeal along with the application shall be heard out. Full stop. The appellant, comma, along with the copies as indicated above, comma, shall also serve a server copy of this order on the respondents and file an affidavit of service in that regard on the returnable date.
The plaintiff response, earlier occasion your lordship was pleased to direct the same also. Plaintiff respondents.
আচ্ছা যেখানে respondents বলছে plaintiff respondent numbers
1 to 3.
1 to 3. Because of service of notice of the appeal and the applications on the
Other
pro forma respondents are dispensed with, since they were co-defendants along with the appellant in the
There's
trial.
been injunction also sought for against the other defendants. Get for deal.
Right. Suit is pending.
Suit is pending.
আচ্ছা যেখানে বললাম
Learned advocate of the lower court.
plaintiff respondents along with their learned advocate appearing in the trial.
This is a contempt matter, my lord, but I have a prayer, my lord.
Contender is beside you.
Yes. My lords have been pleased to prima facie satisfy that there is an act of contempt. Directions have been given to file affidavits. Affidavits are complete. Matter is ready for hearing, but the time is over. Time is with me today.
The
my lord will
heard
keep.
for a day possible.
The my lord will keep.
We'll come back tomorrow then. Let it remain in the list.
The next week.
Next week?
Next week.
Not tomorrow?
Not tomorrow.
Why?
I have to senior. I have to.
Who is appearing?
Mr. Ghosh, Super Ghosh. I have to sit with him once and.
So let it be
make-
fixed on Monday.
Very good. Due to we have to record something today because
Yes, yes,
all of you are
that's a very essential. That's very essential.
due to paucity of time, comma, the matter cannot be taken up today for hearing. Full stop. Learned counsel for the
That's
petitioner praised for the matter to be listed on November 17, 2025. Full stop. Accordingly, let the matter be listed under the same heading on November 17, 2025. Thank you.
Great.